Green present. Good afternoon.
Good afternoon, Your Honor. This is our motion. Do you want me to identify the case?
I just identified it.
Okay.
On your docket number. So give me just a minute to open up the digital file. A respondent's motion to modify temporary parenting plan regarding summer visitation dates, exchange times, passport return, and care of child. Is that correct?
Yes, Your Honor.
Right. And then following the noting of that, I do have several declarations that have been filed in this case, most recently July 6th. Has there been anything filed since July 6th?
I believe those were our late filed pleadings in response to the late filed responsive pleadings from Mr. Zandy's office. Those should be the last declarations and responsive declaration from my client.
Okay. Yeah, the last thing I have bench copies that were filed on July 6th that have also been scanned in. Mr. Zandy, anything else the court should have beyond July 6th that would have been filed by your office?
No, I don't believe so, Judge. We did file on June 28th. There should be June 29th. My client's response to that, as well as several exhibits that we asked the court to consider. So I think you got that and likely reviewed that in anticipation of today's hearing, and would just submit now to save time that there is a housekeeping issue related to what we did receive. We would ask the court to not consider any child-related hearsay that's contained in mother's initial declaration, and it's substantial. There is a lot of information which is reported as coming from the child. My client obviously disputes that, does not believe that is reliable information. We'd ask that you not consider that. Also, we would ask that you not consider any information that was provided on SIR reply that exceeds local rule 88 pertaining to the amount of volume and declarations that were provided, again, by the mother. The court rule specifically states that SIR replies are limited to 4 pages in total. Mom filed a 5-page declaration, in addition to 2 lay witness declarations, which by my count exceed about 8 or 9 pages. I don't think the SIR reply on the from the lay witnesses really provides much information, and we're just simply asking you to, again, not consider that information as one of the declarations. I don't even believe is based on any personal knowledge. Rather, there's 2 extra pages from the Jade Chamberlain individual that continues to talk a lot about the issues that are being received, more than likely from Miss Wynn, who I believe is her mother. That's our preliminary objection.
So I do not believe we exceeded the page limits. If I recall, I think my client's signature page is the only thing that's on the extra page. We were careful to make sure that we meet the local rule requirements, and the information from the child substantiates the pictures and documentation provided. So it does provide context and information that Mr. has not relayed or provided to my client about incidents the child has been involved in during his care. So they are relevant and important to document the issues that continue to arise in father's household. And the supplemental declarations are from personal knowledge. They state from conversations or information that were provided to them, either from the child or that they had seen personally, especially the declaration of Jade Chamberlain does provide documentation of things that she saw, witnessed, and the child told her about concerns in father's household. So if the court is going to consider the information and put context to the pictures that are provided, that my client's concerned about the care in father's household, the court should consider those documentation.
I'm going to reserve ruling on those 2 matters until I hear argument, and I'll make a determination about admissibility at that time. So Ms. Green, go ahead with your argument on your underlying motion.
Thank you, Your Honor. So we are here on several factors that are all related to the temporary parenting plan that was issued on March 7th, 2023. The first issue that was brought to light was the request for summer visitation that had been resolved finally after negotiation with opposing counsel, as they requested a continuance, but this was cited on before that event was to occur on June 30th. So we were able to negotiate an agreement as to mother having that time for the child to attend a family event. We do want to bring to the court's attention, though, that that event was listed in the original materials for a parenting plan, and father specifically requested that time when he had summer visitation. So we are still asking the summer visitation language change to allow each parent to have a priority time each year. Currently, it just allows father to pick times every summer. We don't think that that's fair or adequate to allow both parents to have specific special events and times each year. So we are asking for that. to be included. The second issue is regarding the exchange times for Wednesday, Thursday pickups. Father currently has every Wednesday from after school or 6 p.m. if no school to Thursday after school or 6 p.m. if no school. The child was being homeschooled during the previous school year and is expected to attend in-person school next year. But the issue has been that father would continue to hold the child overnight to the next day, to the end of the day, instead of returning the child to mother's home for homeschooling. In fact, there's been numerous incidents where father has picked up the child at 4:15 and returned at 4:15 the next day, despite the child being homeschooled. So there's been requests for him to return the child at 8 a.m. He refuses to do so. This was an ongoing issue since the entry of the order in March. We are asking for clarification rather than filing contempt on that matter, but we are wanting to make sure that the child is returned promptly, his father is following the schedule, and so mother isn't having to wait 15 minutes to half an hour as father acknowledges that he can't make the 4 o'clock time in his own declaration. So we're asking for clarification, ensure the child is returned before school, or if he was homeschooled, is returned that morning instead of in the afternoon. For the child passport request, it was a misstatement about a passport return. There hasn't been a passport obtained. It's the paperwork return that is the issue. So both parties provided documentation. Mr. Zandy's office did provide documentation to my client, but my client made it clear that it wasn't adequate to obtain the passport. She talked directly to Mr. Zandy's office, acknowledged in the paperwork, which was provided in color and bench copies, so you could see the documentation is partially completed in blue ink, and the application specifically identifies it must be in black ink. My client attempted to obtain the passport, was unable to because of that issue. Originally, the first documentation didn't include his ID and information that was required to acquire the passport. So mother has not been able to get a passport for the child because father's failure to provide the correct information in the correct form, in the correct color ink, which I know is a simple issue, but has not been resolved. And we had to file this motion. And it's been 4 months since the entry of that order, and this hasn't been able to be completed. The order specifically said that within 14 days of the request, that information would be provided. We're now at 4 months and we still do not have the adequate paperwork for my client to obtain that passport. On the next issue, we are asking that some information be put into the parenting plan because of ongoing issues. My client's concerned about the child being bullied and abused during father's visitation. The child has come back with bark dust in his hair, spiders, and has complained of bullying and altercations with children in the park, and father not intervening or doing anything. In fact, specifically states that father's on his phone talking to somebody and just isn't paying attention. And this is a real concern because the child should not be physically assaulted by 3 people in a park or anyway, emotionally, verbally, physically abused by other people. Father needs to intervene in those situations. He advised that he minimalizes incidents in his report, but it is something that we want to make sure that he is providing adequate safety and supervision during his time. Related to the child's care, we're also concerned about his cleanliness. The child has come back completely covered in, completely covered in his hair with sweat and debris. He's come back without having showered, smelling musty, a number of issues which mother is concerned about every time he returns from father's house. We're concerned that there isn't showers, there's not adequate shampoos and soaps being provided. The child is not encouraged or does not take showers at father's house, and these are long weekends that he's having with him. So we are asking that provisions be provided to ensure the child receives appropriate health care and items to shower and clean himself while with father. And regarding the child's care, the other issue is about providing appropriate nutrition and meals. The child reports to the doctor eating processed and fast foods. Medical advice was provided to make sure he's provided healthy and nutritious meals. That's been provided, and father continues to provide either inadequate or unhealthy food items. This is a concern for the child's health and growth. There's a history of the child failing to thrive. We provided those medical records and issues with
Again, Your Honor, I'm going to object to anything that we received on the SIR reply. The only thing that was the allegation in the initial declaration of motion was a problem with him eating Cheerios or Fruit Loops or something of that effect. We didn't get any information from the doctor. We didn't get any of this testimony until, again, the SIR reply 5 or 6 days ago. So again, that's contrary to the rules. We'd ask you not consider any new information we did not get to respond to. That is, again, based on hearsay from the child.
Yeah, I will sustain that, and I'll just ask Ms. Green that you move on to your next point.
Yes, Your Honor. The last issue for consideration is compliance with his disclosure of records. Under Section 4D of the current parenting plan, it states that Mr. Curtis shall complete domestic violence treatment with Olivia Lovely. He shall continue in treatment with Miss Lovely until she releases him from treatment. But most specifically, he shall provide compliance reports and proof of completion via our family wizard. So at this point, I think he acknowledged in his declaration, he's provided no such compliance reports. He's provided no information whatsoever about where he is in his domestic violence treatment. He states in his declaration that he's no longer in groups, he's on a one-on-one, but has provided no corroboration or documentation. So he's clearly in violation of this provision. We have no information on whether or not he's even still completing these. So we're asking the court to require him to provide such reports. There's no way to confirm if he's following the court's orders or not. And so we are asking that information be provided. He have deadlines in which to provide those. We understand that there should be monthly reports available and he can provide those. He just chooses not to. And again, this is 4 months since this order has been in place and he has made no attempts to provide anything. So that is a concern given the history for my client that he's not compliant with those requests and reports. Finally, we did make a request for attorney's fees. Obviously, if it wasn't for the conflict, there wouldn't be a need to proceed to motions for clarification and to enforce these orders. The summer visitation could have been resolved if father was reasonable. You can see text messages that my client provided about asking to exchange dates on another occasion for a birthday and his non-response to the request and basically belittling my client. Obviously, if there was a way to communicate, it would be helpful, but there isn't. And so we were forced to file this motion, at least for the child to attend a special event for the child's sister and family, which luckily we were able to come to an agreement before it occurred. But the other issues are still outstanding. We still don't have any way to confirm father will follow the scheduled times for the visitation, even though it's very clear that he's supposed to return the child before school starts. We still don't know when we'll ever get the passport information that's needed to acquire the child's passport. So we're asking for a deadline for that. And the compliance reports and the care of the child are of utmost importance. And my client needed to file a motion to get those informations provided because he has not done so voluntarily and doesn't provide any information to my client. She's unfortunately finding out issues, ongoing since the entry of this order.
And do we still have Ms. Corey on this case?
My understanding
Yes, Rob.
is she's on the case, but my reading of the order for the JL said that she would be discharged after her final report. So that we did provide notice, but I don't believe she has any further participation in this except for to attend a trial.
Okay. So it sounds to me, and correct me if I'm wrong, there was a little bit of back and forth on this. On number one, that you've requested the special event June 30 to July 2nd. That's no longer an issue. Is that correct?
The event, yes, has occurred and my client was able to exchange dates for attendance, but we still did need to bring it up and had to bring it up in court and communicate to resolve that. But we do want to still add in language that each parent would have a priority, even or odd years for summer. So it's not just father every year for some fairness.
And then I'm just trying to go through the things that I think might not be issues, but correct me if I'm wrong. So clarify for me what you're requesting on the passport at this point, because I'm reading the responsive declaration. I'm seeing an exhibit where father signed. What is it that you're still asking for specifically?
So the documentation father provided was not appropriate to issue the passport. It was completed in blue ink. We need a fully completed passport application from father in black ink, showing and also completed notarization in black ink and having his documentation. I believe his ID is required for the full complete passport application.
And Your Honor, just to set that straight, a simple phone call and I would have readily agreed to do that in black ink. This is the first on the motion we heard of that. We thought that issue had been resolved since March. So we can put that one to bed, which we probably could have done on March 29th had we known. So that should be an easy one.
Yeah, and I just ask, I've tried to do my kids' passports and there's always something. So, I think that Ms. Green, it sounds like that's something that can be readily worked out between the parties because I do see substantial compliance with the court's order by way of father filling out the form and signing it. If it was done in the wrong ink, it sounds like Mr. Zandy is going to work with you to get that corrected. So I'm not going to issue any formal order on that. Certainly, if that doesn't get done shortly, please bring it back. But I think the parties can work on that. So Mr. Zandy, then I have read the response, so I don't need you to belabor the point, but let's just go through kind of point by point. Summer visitation schedule is father wanting that to change based on the request?
No, and I would take that a step further. This again is an issue that I think a phone call or two, we resolved it. It's agreed. So what child had visitation with mom. As far as changing future orders, I don't think that's appropriate. I also don't think that is adequate under the law. Again, to change an order, and this is a brand new order that was entered back in March. There was no motion to reconsider. Nothing has changed. There's been no change in circumstance, which is required to modify a parenting plan. It's just basically a second bite of the apple from Ms. Nguyen with a new legal counsel to ask for that change. We don't believe that's warranted. We're also on temporary orders. If something happens next year, either party can bring that issue. We didn't give you much of a response on that because I had apparently mistakenly believed that when we acquiesced to allow that visit and that special function, that put that issue to bed. So I'm somewhat surprised to hear argument pertaining to that. I thought that was resolved as well.
Yeah. So on petitioner's request, or excuse me, respondent's request, but petitioner on this motion, the request to change the temporary parenting plan with regard to summer visitation, I am going to deny that. I did review Judge Evans' notes. This was entered just a few months ago. I also don't find any change of circumstances that would warrant changing his ruling on that issue. And again, I would note that certainly in the final orders that may change following trial if that's the direction this case goes. So then number 2 appears to be a request regarding exchange times. Mr. Zandy, your input on that request.
Sure. And this is, again, somewhat of a surprise. It's a case in which Ms. Nguyen was previously represented by very competent and capable counsel. Again, this was one that was decided back in March. It's what that time would be. Court, as we typically see, and it's not uncommon, just kind of ordered the generic Wednesday after school to my client. There's no defined time on that. Court didn't recognize that this child was at that time, and again, 2 months or 3 months before school being released, homeschool. So Ms. Nguyen is in the position of essentially deciding when school is out. We didn't know what that meant. That was a loose end in the order. Again, easily resolvable. A short time after that was entered, I believe it was in April, we provided you the letter that my office sent Ms. Nguyen asking and making a suggestion that let's make it 6 o'clock on Wednesday to 6 o'clock on Thursday. We received absolutely zero response to that. That was crickets, and didn't hear anything confirming that or making alternative suggestions until we get, again, the motion. My client is simply suggesting and willing, again, I think very reasonably, to keep that one of two ways, either what we had proposed in that letter that went unresponded to, or alternatively, we can just call that Wednesday from 4:30 until the following day at 6 o'clock. I would think that either is appropriate. He gets off of his work at 4 o'clock. So as he states for you, he goes directly to pick up the child and start his time. What we don't like is identifying 4 o'clock specifically when Ms. Nguyen, who again, as Judge Evans pointed out last time, has some controlling type behaviors, suggests that it start at 6 or 4 o'clock on Wednesday, knowing that my client is not available, and then in the next day at 8 o'clock, which essentially takes 10 hours away from him. We don't think that, again, is proposed in good faith. We don't think that it's appropriate, especially considering the efforts we made that went unresponded to. I think either solution is a viable one. For purposes of today, I believe we should just call it Wednesday at 4:30 until the following day at 6 o'clock, which again maintains the brunt of the court's order from March.
And Ms. Green, just to clarify, in your, I guess, proposed order on that point on number 2, you were proposing Wednesday at 4 o'clock, but ending Thursday at 8 a.m.
And that's because the court order says from every Wednesday after school or 6 p.m. if no school, to Thursday after school or 6 p.m. if no school. So
But
you're asking,
were you intending that to be 8 p.m. or are you proposing 8 a.m.?
it was 8 a.m. because the child needed to return to homeschooling with mother and father was not returning him. So that is the issue, is father would just keep him throughout the day that he was supposed to be homeschooled. So the court did say from after school, but the child wasn't going to school.
And the problem with that is under that logic, child goes back to mom at 8 a.m. and is allegedly in school and homeschool from 8 a.m. to 4 p.m. Again, that's part of the issue we have with Ms. Nguyen. It's been that type of logic throughout. And the court entertained that again in March, and that didn't resonate with Judge Evans, who entered the order accordingly. I think the only thing we need to shore up, which we tried to do again back in April, is just the time that my client picks up the child to start his time on Wednesday. My client can take the child to school on Thursday. He can pick the child up from school on Thursday. And the child's transitioning from homeschool that he was in the past to now being in brick and mortar regular public school here beginning in September. So again, surprised we're arguing this and spending time on it and fees in court, but I think there's very simple, viable solutions. And the letter we sent again went unresponded to.
So it sounds like what is in agreement is that the pickup time, or excuse me, that we would change the time to 4:30 on Wednesday, 4:30 p.m. on Wednesdays.
And I think that just gives clarification that the parties need a designated time to pick up Benjamin as opposed to kind of the open-ended after school, which caused problems during homeschooling. We can arrange that and work through that now that he starts in September in a regular school setting. But again, probably best for everybody just to call it 4:30, 4:30 on Wednesday to 6 o'clock on the following Thursday, which was, I believe, the court's intent a couple months ago.
Ms. Green, is there an objection to that minor tweak from Judge Evans' language?
So we would ask if father is going to have the child Wednesday after school, that he is picking up the child from school. My client shouldn't have to pick him up and then have him delivered for father's visitation. So the issue was that we filed this before school ended and we had waited and set over a continuance. So this was an issue at the time we filed. Now that the child will be going to regular school, father should pick up from school, or we could set the 4:30 time if he's not in school. So I think that would be appropriate. So mother has a fixed time that father will be there. He's been consistently at least 15 minutes late. That's the issue. So father, if school's in session, will pick up from school. If we need a set time, then 4:30 if school's not in session, so that we don't have this debate on time. And then father is responsible for taking the child to school the next day, and mother will pick up from school, or 4:30. So we have a set schedule. That's been the issue.
Well, that's contradictory though, because if my client is 15 minutes late now because he gets off of work at 4 o'clock, why are we going to make him pick the child up from school at 3:30? Makes zero sense to me. And also, it was never meant to be a 24-hour period set by Judge Evans. It was beyond that. So that 6 o'clock on Thursday, again, that provides my client with 3 additional hours that he can spend with Benjamin, take him to the park as they traditionally do, ask him how school went, and do those things. I mean, that's part of my issue is that you're asking for orders being Miss Wynn that are intentionally setting up the other side to fail, which again undermines the value of her argument in this, which has been a plagued this case for at least the past several months. So I think the 4:30 to 6 the following day makes the most sense.
And I think, Ms. Green, I think the court's concern is here we are just months after Superior Court judge elected in this county issued a very detailed parenting plan, and we're trying to now revise it and redo it without any new real substantial change. So I am somewhat reluctant to grant this request, but given Mr. Zandy's willingness to change the language, I would agree to sign a new order that includes a 4:30 p.m. pickup. I'm not, because of the work schedule and because of how the initial parenting plan is worded, I'm not going to require that be done at school. It's simply going to be a 4:30 p.m. Wednesday and a 6 p.m. Thursday, ending 6 p.m. Thursday. I think that's what Mr. Zandy, you had proposed your client would be agreeable to.
Correct. That 6 p.m. is already written in the order, so I just kept it the same.
Okay. So I would agree to make that change. I think we've already addressed the passport issue. Number 4 on your request, Ms. Green, is a request that this court order appropriate care, supervision, meals, etc. Again, going back to review of Judge Evans' initial ruling in this matter on the temporary parenting plan, as well as the initial GAL involvement. I am going to decline to make any ruling as requested by you under number 4. I think that this is an issue, certainly if the parties want to raise at trial, they can. I don't find that there is any basis for the court to amend the temporary parenting plan with this language. And I think it goes to Judge Evans' concerns as indicated in his notes at the time he entered the temporary parenting plan. There seems to be this need for overt control over during the other parent's time. So I'm going to deny the request on number 4. I think that leaves us on the substantive issues with number 5. your request that petitioner provide compliance reports for DV treatment with Olivia Lovely. Mr. Zandy, in your responsive declaration, my understanding is that is something that's being worked on, and that perhaps there was an evaluation done, but no active treatment being recommended. But tell me if I'm off base on that.
You got the gist of that. You're a little bit. I can give you more detail on what's specifically happening. He continues to meet with Olivia Lovely. Again, he was, I recall, at a low risk of offender score. She recommended about half of what she typically does. That was based in large part on Ms. Wynn's information that she gave to her. And I can tell the court as an officer thereof, I believe it was on Friday, the last day I was out on vacation, I did receive an update from Ms. Lovely. I am happy to forward that on to Ms. Green. If the court wants me to file that, I can. I will tell you it's unspectacular. It simply states that my client is doing everything that he's supposed to, and he's in satisfactory compliance therewith. Again, to include that in a motion, again, to suggest that he should be literally providing new documentation every time he goes to treatment, which is the suggestion by Ms. Wynn, is not completely manageable. It's also extremely unrealistic. That's not how it works. They don't give you a gold star or a silver star every time you walk out of that treatment. They will get you updates as they can. The court's aware with how this works. Ms. Lovely is extremely busy, as are a lot of the treatment facilities. She will get you information on a pretty much as needed basis. That's what she's done. And I will forward that to Ms. Green. But again, a simple phone call and we would have worked through that, and I would have been happy to provide it, as opposed to filing responses and eating up the court's time with a motion, which again, I don't think is legally based. I would also say that my client is required to comply with treatment and provide updates on that. Again, the order was entered in late March. He can only do what he can do. He's attending, he's doing what he can as far as getting the documents out. There's no order that specifies when he's to do that by. And I think at the time, the court knew, opposing counsel then was aware enough to know. I certainly understood that as we got it, we would forward it and make that available. Never anticipated that we would be here debating or arguing, again, that issue on the minutia, which is a complete waste of time and money. So I will forward that to Ms. Green by the end of the day.
You know, I'm just looking at 4D on the temporary parenting plan. I do see that it doesn't set a specific date. It does state that a DV evaluation should occur, or excuse me, that he should complete DV treatment with Ms. Lovely, that he should continue in treatment until released. He shall provide compliance reports and proof of completion via our family wizard and sign all necessary releases so that the respondent can confirm the same with the counselor. So it sounds like perhaps the only thing, I guess, missing from this currently might be releases for respondents so they can independently confirm these items. But again, there's no date given on this for compliance.
Yes, Your Honor. Can I speak briefly? I apologize. I just want to respond since Mr. Zandy had an opportunity to speak about information that wasn't in the record.
Well, it was based on my questioning for clarification of what was going on with treatment. So I wasn't quite done. I'll come to you in just a minute. Mr. Zandy, can you tell me, or do you know when the evaluation and treatment began?
I think the evaluation was done prior to us being last in court. I think Ms. Wynn, and she gave input to that, like I stated, again, pursuant to the order. I think everybody acknowledged that at the time of the hearing, if memory serves me correctly. He was engaged in treatment at that time. He continues to be engaged in treatment currently. He hasn't graduated. As soon as he does, I'll provide that, but we can't produce something again that doesn't quite yet exist. I can say he's doing satisfactory to above and beyond what is satisfactory. So he's doing everything he can in that. And again, I'm not sure what else can be said or complied with or specified in that order that's not already there. So that's kind of my 2 cents on that issue.
Ms. Green, go ahead.
Yes, Your Honor. So we did reach out to Ms. Lovely since Mr. Zandy is speaking about what Ms. Lovely has provided. And I'm assuming she's provided the same information that we requested from her. And there are monthly summer reports that she can complete. And my expectation is does complete on a regular basis. So we believe Mr. has those available to him and just chooses not to provide them. In fact, she provided the monthly summary from June just last week when we made an inquiry to ask the status of where he is at. And I mean, there's substantial absences marked on her report because we received these after our materials were turned in. We weren't able to provide these, but our materials were already late due to the holiday and the late response from Mr. Zandy's office. So if Mr. Zandy is going to speak to it, they are clearly available. They're just not being provided.
Okay. So here's what I'm going to do on that issue. I think that the temporary parenting plan, because it doesn't set a specific deadline, for compliance with those things. It just states that compliance reports and proof of completion need to be shared, and that proof of completion hasn't occurred yet. What I will do is set a review date just on that sole issue to verify that that has been shared and any necessary releases have been signed so that respondent can get that information. And so I'll reserve ruling on the whether the court needs to further get involved with the compliance reports. Let's set that review date for about 30 days from now. So that would be our August 8th docket. And Ms. Green, I'll make it incumbent upon you, if you no longer need to address this issue with the court, please strike that hearing. Otherwise, the parties can come back and I will inquire into whether we've had compliance with the sharing of the Olivia Lovely's compliance reports at that time, as well as any releases that need to be signed.
And I think the releases have been signed. I think that was done even before March, allowing Ms. Nguyen to talk to Ms. Lovely. So I think that issue has been largely resolved. And it sounds like counsel has the exact same information I do. I wasn't aware she had that. I don't have anything else to produce at this point. They could always subpoena that information if they needed to from Ms. Lovely. I'm just not really sure, what more my client can do.
Okay. Well, I'll keep this on for review for August 8th. And I think that my stance would be, as long as any compliance reports that father has received have been shared with mother, I will deem that compliance. If he's completed treatment by then and has a completion certificate and he shares that with mother, I will deem that compliance. Okay. And I know both parties had requested attorney fees on this matter. I think it's somewhat unfortunate that some of these issues were raised in such a short amount of time to the temporary parenting plan. I certainly hope that isn't the pattern going forward. So what I'm going to do, I'm going to deny both attorneys' requests for fees at this time. But certainly if this becomes a pattern in this case where we're reevaluating temporary orders just months after they're addressed with no substantial change, certainly my ruling will likely be different in the future on attorney fees.
Fair enough. Thank you, Your Honor.
All right.
Do you want a presentation date on the 8th at the same time as that review hearing? Is that?
Thank you. Yeah,
So
let's do
this
that. I
is,
think that's a good idea.
Dennis
Is it Einerson? Am I pronouncing that correctly?
Yes, ma'am.
And Janelle Anderson.
Yes.
And I'm just double checking. Are there proposed orders you would have filed with the court on this?
So I have filed a proposed parenting plan. We are only here on our motion for a temporary parenting plan. In Ms. Anderson's response, it was a response to the entire petition. And so she does bring up financial information and child support. That is not something that we are addressing today. I anticipate we will be addressing those financial issues pursuant to the mandatory settlement conference under the local court rules. Or if we need to bring motions at a later date regarding those particular issues, that's fine. But for right now, we have parents that share 3 children. And we need to have a temporary order in place for them to follow going forward until we can ultimately resolve this case. I will let the court know, because I'm sure if reading the materials, there is a 4th child. Reese, he's the older son of Ms. Anderson. Unfortunately, my client has absolutely no legal authority to this child. And it's my understanding from the filings of Ms. Anderson that this child has also been adjudicated under another court order with his actual biological and legal father. So that's the particular reason why Reese is not included in this documentation. The 3 children, Theo, Henry, and Nora, are my client's children. And so that's why they're the only ones that are addressed in the pleadings.
I also filed a proposed parenting plan.
I don't either. There is no note. Yeah, I don't have any original orders. Let me just look through my stack one more time.
The court wouldn't necessarily have a temporary order or proposed order from Mr. Einerson yet. We were going to wait until we had the court's ruling here so that we could prepare those orders based upon what the court rules today. But there is the proposed parenting plan. So that's there have been a few other little issues that have come up that ultimately would change whatever proposed order we would have prepared. So that's why we held off on that until I have the court's ruling from today.
Okay, so just so I'm clear, you are asking today just for a temporary parenting plan, correct?
That is correct.
But have you filed your proposed temporary parenting plan?
Correct. And there are just a few changes. Obviously, we're just asking the court that it order the temporary parenting plan that is proposed by Mr. Einerson. There are a few little things in it that we wanted to make sure that the court does order, specifically restrictions on mom's time, where she is not allowed to have the children have any contact with known sex offenders or violent offenders. Father is proposing every other weekend, Friday from 5 to Sunday at 5 with mom, but every week during and knowing her work schedule, she would have the children Monday afternoons from 5 to 7:30 and Wednesday from 5 to 7:30. My client has had a long, illustrious military career. He is in the Army National Guard. He is currently working on doing an early retirement on that. However, it's my understanding that coming this fall, he may have at least one particular day that he needs to go up to Tacoma in order to go to Joint Base Lewis McChord in order to engage in some exercises he has to do for his National Guard duty. So we are requesting that during that military time, if it falls on when dad should have the children, that the children go with some family friends that are noted in his proposed order. And then the only other thing that I think that I wanted to make sure that the court also considers today is the children, and granted they're very young. We've got Theo, who is 7, Henry is 4, and Nora is 2. Theo and Henry tend to be involved in a lot of extracurricular activities, including baseball and soccer. There's a deadline that is coming up on the 17th, I believe, that dad wanted to get the boys signed up for their respective sports. And so we are asking that the court allow father to do that. And the only other thing that I would add, and I do apologize to the court, I typically add these into my parenting plans, but we just want to make sure that there's added language, preferably under section 14 other, where neither parent would be allowed to discuss any of the court proceedings with the children. I think this court would agree it is never appropriate to talk to the children about adult stuff and what's happening with the court, especially when we're talking about a 2, 4, and 7-year-old. But they have no business. They wouldn't have any understanding, nor should they, of what's going on. And in addition to that, I would ask that both parents refrain from speaking disparagingly about the other parent around the children, also being responsible to make sure that nobody else is talking disparagingly about the other parent around the children. I don't think that's beneficial for anybody involved, especially when we're talking about these 3 young children. So those are the requests that we have for the court today. We do believe that they have reason to believe that the children have been around an individual by the name of John Morgan quite a few times. He is currently charged with rape in the first degree, child abuse, witness tampering. He had a sexual assault protection order back in 2020. He has another first-degree child molestation charge in July of 2022. Also a lengthy history of DUI, possession of drug paraphernalia, domestic violence. I think the court gets kind of where I'm going with this. This is not a healthy individual to have around minor children, especially when the charges that he is being charged with are regarding sexual assault and sexual molestation of minor children. So that is the reason why we are asking for the restrictions. If Ms. Anderson wants to date this person on her own time, that's none of our business. But the children should never be around somebody who has this kind of violent history.
So let's start with that issue, Ms. Anderson.
I've called 10 lawyers and I'm unable to get anybody to represent me because of, I don't know, various reasons. I have my own parenting plan that I filed. Are you able to see that? I'm requesting the same amount of time that we agreed on with the mediator. We are currently seeing the kids 50-50, and that's what I'm asking for. And the person that they are discussing has not been seeing my children. He saw my children one weekend. And after that, obviously it was a very big problem, and he has not seen them since early May.
All right, you had a question for me, I believe. What was your question?
Sorry, what did you say?
I believe you were about to ask me a question, or it seemed as if the court was about to ask me a question right before Ms. Anderson spoke.
No, I asked Ms. Anderson the question.
Oh, okay.
Yep.
So the problem that we see, Your Honor, is that the children, and they're very young, tend to have spontaneous comments with dad after being with mom. And so it's spontaneous comments like, hey, we had a great weekend because, John was popping wheelies on his motorcycle, or was playing Xbox with us, or was in mom's bed when we got up in the morning. So that's why it's concerning. I don't have any proof that Mr. Morgan is no longer around. We do know that the children still indicate that his possessions are in mom's house. And so that's why this is very concerning. To also kind of backtrack a little bit on what Ms. Anderson was saying, I am in receipt of her proposed plan. It is identical to what the parents had worked up in late March, but never filed. But the problem is this kind of 50-50 split, as indicated in my client's initial declaration in support of this parenting plan, is that, I mean, valid effort, I think, on both parents' parts to follow that. But after a couple months of following it, it became very difficult, not only for the children, the routine was quite off, but also for the parents to kind of balance that particular plan. And I think the court would agree, 50-50 only works in very, very unique, specific situations. Doesn't always work in situations where you have parents that are working, when you have children that are involved in extracurricular activities, when you've got separation from the parents. It's not like they're right next door to each other. Mom lives in Battleground, dad is out in Woodlands. So this is becoming problematic. And as Mike indicated in his declaration in support, he said that, we tried it, but there were often times where mom would only take a couple of the kids kind of on some days, other days maybe would have all of them. So my client oftentimes ended up with the children, the primary, most of the time. He had the majority of the time anyway. So as much as I think that they really went into this idea that it might work, it's not working for the children. It breaks up the routine entirely too much. And over time, especially with school schedules and whatnot, this isn't going to be conducive for the children or the parents, which is why we are requesting that dad have the majority of the time and be the primary custodian, and with mom having every other week or every other weekend visitation. And during the week, she's able to see them on her days off.
And then Ms. Anderson, the schedule that you're proposing, is
Yes.
that essentially status quo with what you folks have been doing for?
Yes, since we agreed on it at the end of March, and he continued to be gone for military work for the next 6 weeks, I believe. And I moved out the first week of May, and we've been doing the schedule 99% since then.
And what is your statement to the court about how this is working for the children?
I think it's working fine. They get to see both of their parents regularly. They get to see their grandparents, their brother who lives with me, who Dennis has now rarely seen. I don't believe it's good for my kids that he is proposing that. And I don't think a lot of it is honest.
So here's my take in reviewing this case and kind of comparing the two proposals that are before me for temporary parenting plans, which is all I'm being asked to decide today. I think the language, Ms. Bash, that you proposed regarding, and I'll pull it up here exactly. I just have to switch back to it. Obviously, well, let me back up. Neither party is asking for any limitations to be found or reasons for limitations. So obviously the court will decline there.
Well, we have asked that, Your Honor. We did ask that there be restrictions in there. The limitations don't necessarily fall under the statutory limitations, but the restrictions are who's allowed around the children on
Right.
parenting time.
Right, I understand. And what I'm looking at is the big picture here of nobody is alleging abandonment, neglect, child abuse, domestic violence, assault, sex offense, etc. So that's what I mean by no petitioner isn't asking that of respondent. Respondent is not asking that of petitioner. So other than what appears to be perhaps an individual that respondent may have come in contact with this other issue that now, at least at this point, does not appear to be a current issue, I am going to decline any limitations on parenting time. I will decline to include the language. I think Ms. Anderson has adequately addressed that in her response and her statements to the court. Looking at the schedule, I guess I want to know from you, Ms. Bash, what would be the reason, I guess, for not doing what the kids have been used to for months and months, where it seems to me as if this might be one of the few families that could make this work, where the kids get the best of both worlds and get 50-50 time with the parents. I'm not seeing anything real significant in the record that would cause me to deviate from what these kids are used to. So if you have any further information that you think would be helpful in support of your schedule, please let me know.
Absolutely. So what we do have is we know that based upon the routine that father has with the children, activities that he does with the children, it keeps them in more of a routine. They are happier, healthier. The court is in receipt of the declarations of other some family members, some not. Some people that just happen to know this family and in the community have all recognized that the children do better when they spend more time with the dad. The other thing that I'll reiterate is that even though they came up with this plan in the end of March, dad did have some military training he had to go to, which is why they decided to put kind of something in place between them, although it was, again, not court ordered. They put something between them, is that at the time they had decided to break up. And so dad wanted to ensure that mom didn't go rushing and try to get a parenting plan different on her own. And so they tried this particular plan out. It's my understanding from my client that he did not think that this was going to work for the children, that it was too much back and forth. There's a lot of flip-flopping. I think they trade, and Mr. Anderson can correct me if I'm wrong, but it's something like every Wednesday, they trade off and on as to who has a Wednesday. It gets very confusing for the children. And right now we do have Theo, who is well, summer break, let's be real, but Theo, who is 7, Henry, who is 4, and Nora, who is 2, they all have a preschool schedule, especially for Nora and Henry. And then Theo has, schooling. And so in order to keep this all beneficial for the children, especially during the school year, we're looking at a little boy that if he's flip-flopping back and forth between mom and dad's house, that's not going to be conducive for his education. And so that's dad's biggest concern. He did not think the 50-50 would work. He thought, okay, I'll be amicable. We'll give it a shot. But even he is noticing that there's a distinct difference between his children and how they're dealing with it, doing the 50-50 versus when he had most of the time. When they started doing the schedule, mom also, as I mentioned, would take 1 or 2 of them, maybe, was oftentimes leaving the kids saying, could you keep the kids longer, which dad was perfectly happy doing so. And the children seemed to benefit from that particular situation than it was the back and forth each week. And so I don't see how long-term this is going to be useful. Also, just to kind of piggyback on the previous hearing, I don't want to keep coming back and doing temporary order after temporary order and doing all these changes when we do discover ultimately that dad's right. This is not working for the children and it's not working for mom and dad's schedule. And so that's why we are requesting that we kind of go to a more traditional stance where we have a primary parent. The other parent does get parenting time and visitation time, as we had proposed. But I don't see how long-term this is going to be beneficial. And I certainly don't want to have this flip-flopping back and forth.
I was driving, I moved out and I was driving Theo and Reese to school in Woodland on my days with them. There was no back and forth flip-flopping. There was no, I didn't not take them. And Nora, as far as I know, isn't in daycare. The last time I asked Dennis after we agreed she would start daycare, she hasn't. And I continued to keep Henry on the same days with his dad because he has daycare on those days, on Monday and Tuesday. And Dennis always has him on Monday and Tuesday. So regarding school and daycare, it's kind of irrelevant because we've already done this and we've been doing this fine, just fine. And I'm really happy to see that people all over the place realize my kids are doing better on this 50-50 schedule. And it's not necessarily that they're spending more time with their dad, it's that they're spending equal time with their parents.
Yeah, I mean, I think there's really something to be said. Other people may see this differently, but I think there's something to be said for Ms. Anderson's proposal that does maximize time with both parents, where I don't find any reason to limit the time with either parent. And in fact, both parties have given proposed parenting plans that allow for joint decision-making on things like education and healthcare, et cetera. So I don't, sitting here today, and certainly through trial and as additional evidence comes in, I'm very open to reconsidering my gut instinct on this, but I don't see any reason to deviate from the equal time that is currently being given and the current schedule, which also allows for time with their older brother, Reese, who I know is not included in the parenting plan, but there's no reason for me to believe that that's an unhealthy relationship. So I am inclined to adopt Ms. Anderson's temporary parenting plan as far as the schedule is concerned. I'm happy to talk through any other objections you might have to it. But as far as their daily schedules and the split of time, I don't find any reason to change things to Mr. Einerson being primary parent at this time.
Who is the court designating, though, as the primary custodian if we're splitting it 50-50? Because our preference would be Mr. Anderson, obviously.
Obviously.
And Ms. Anderson, your position?
I would like to be their primary parent. I always have been.
I don't know that that's entirely true, but that's...
I put in a FOIA request for the military to show the amount of time he's been gone throughout their life. And I did not have enough identifying information, but I'm sure Mr. Einerson could supply the amount of time he's been gone away from his children for an extensive amount of time. So yes, I am their primary parent. I always have been.
Father maintains the only residence these children have ever known. So the
That's
kids are
because-
enrolled in the
That's because
providers and
he
schooling
told me to
around his
move.
home.
He told me to move out. What was I supposed to do?
Hold on just a minute. Yeah, okay. So we'll try not to talk over each other here. I'm just looking through the different proposals. So in Ms. Anderson's proposal, I am going to adopt that she is the custodian purely for purpose of state and federal statutes, which require that designation. That does not in any way take away from Mr. Einerson. I do take into account that he is keeping the family home as part of this entire process, and I don't find that that means that Ms. Anderson is any less of the parent than she has been through her children's life thus far. So I want to use her proposed parenting plan to look at the schedule.
Your Honor, just quickly, I just got a message from my client that indicates that he was never deployed since the children have been born. So if Ms. Anderson is claiming that he's always gone with the military, I don't find that entirely truthful if father is saying he's never been deployed after the children have born. So we're talking 7 years. He was in school. He did get his master's, but well, first his bachelor's and then his master's, but he hasn't actually been deployed.
He has been gone extensively for training, competitions, drill every single month. There's been a large amount of time he's been gone. Large, not maybe all at once, but he has regularly, consecutively been gone.
Well, and I'm not holding anyone's military service against him here.
No, I'm not either.
And that's why I'm being very clear. I'm not finding fault with any parents parenting at this time, which is why I am going to side with the parenting plan that keeps things as they have been for these children who right now are going through this upheaval because of the decision that the adults in their lives are making. And so I want the kids to remain as normal as they have been, which is why I believe adopting the mother's proposed parenting plan keeps those things the way they are. And again, I certainly take into account that if further evidence comes out through discovery, trial, et cetera, that this may need to be revisited.
Is the court allowing dad to sign the kids up for sports?
Absolutely.
Thank you. And as far as adding that language, I don't think that the court is going to say no about no bad talk about the other parents.
Correct. I think that's absolutely reasonable.
Okay, thank you. I will add that to section 14.
Okay. Is there anything else we need to address as far as holidays from the mother's proposed parenting plan?
I don't think about holidays, but to do with sports, what is the transportation, since Ms. Bosch pointed out that we're not close together? So how will that work when I have the kids half the week? Are we signing them up in Battleground, in Woodland? What is?
Assuming
I
they're
don't
being
know
signed up with the teams that they've always played on, or with those
They've not
particular-
always played on teams. Henry's done soccer one time, and Theo's never done soccer, so I'm not quite sure what Mr. Anderson's speaking about.
Excuse me.
It is my understanding that the sports that he is looking into are those that are in his area, because that's what he is closest to, and he's going to send them up for that. If mom's suggestion here is that they split time 50-50, that's a responsibility that each parent takes on in order to encourage their children to be involved in extracurricular activities, which means that the parents are responsible for getting their children to their activities, just
Right,
as it would be.
So
So could I have them sign up in Battleground then? Battleground has more extensive amount of sports than Woodland does.
Again, I don't have any proof to that suggestion, and I know that Mr. Einerson has already looked into the sports that he is signing the children up, and has expressed that to Ms. Anderson about where he was signing them up when she said absolutely not, don't sign them up. So now that we have that sports are allowed,
Okay.
dad is allowed to do that, provide mom with that information. The only other thing, holidays, Your Honor, you did ask for, and I don't think that there is any significant concerns back and forth between holidays. One thing I would suggest, though, is just that the children be able to have phone calls with the other parents during, I mean, not excessive. I'm not saying you're calling every 5 minutes and ruining the other parent's time, but we would like to recommend that when kids are with dad, that they're allowed to call mom, so that, you know, nighttime, saying good night, whatever, and the reverse would be the same, and the kids are with mom, that dad be able to talk to them, just, you know, check in.
agreed. I don't think there should be any limitation on children making phone contact with the parent they're not with. So I would adopt that language.
Is there some-
Hold on, I want to go back to the sports though. Excuse me, I seem to have something in my throat. So I'm just trying to figure out, are we talking, I mean, we're now halfway through the summer. So is father proposing that he's signing kids up for summer sports versus are we talking about school district sports?
So it's my understanding that the kids are doing sports. Theo just did baseball or t-ball. I'm not sure which, and I'm not sure where that split happens with little ones. I know that he's looking into soccer, which there is, like I said, he mentioned last night when I talked to him that there's a deadline on the 17th. I don't know if that's late summer soccer or if it's for fall. But for both kids, Nora's a little bit young, but I'm sure she wanted to get into something. We could find something. But for the boys, it's my understanding it's the fall sports. But the kids are doing the sports with the same kids that they go to school with, and no, so the same kids that they go to preschool with, elementary school with, they get on the same teams. Sure, it hasn't been that long for this court. It's been very long for me since I was on teams as a child, but it was very important to be with your friends and kids that you know. So that would be Father's suggestion, is that he be able to sign them up for the Woodland teams.
I put in my parenting plan that I wanted Theo moved to Battleground School District to be with his brother. Are we adopting the entire parenting plan as a temporary or sections of it?
I'm just going back to that section here.
Mom hasn't done a motion for relocation regarding a change of schools, so I don't think
Yeah, I don't,
before the court. So that I would have taken out of Mom's parenting plan.
right. Well, I'm not seeing, I see in an affidavit, Ms. Anderson, that you discussed that, but I'm not seeing that in your parenting plan.
Okay, well, like I said, I don't have a lawyer and I tried drastically to get one. So I will try and figure out what I need to do.
Okay. So for purposes of this temporary order currently, what I am going to say, and luckily, Woodland and Battleground are not that far apart. It could be a lot worse. We could be dealing with, Longview to Portland, which does come up in this court frequently. So at this point, I am going to, because Father seems to be the parent primarily concerned with the sporting events, I am going to have you all put into the proposed parenting plan that the kids are to be signed up with, or allowed to be signed up with, Woodland sports teams. And it would be incumbent then on the parent who has the custodial time at the time of practices and games to arrange transportation to and from those sporting events and practices.
So that is on the parents' time. They're the parent who has the children are required to do the transportation or set it up.
Correct.
Okay.
Or set it up, correct. If that means asking the other parent to do it because the other parent is available, that's fine. But yes, to set it up or do it themselves. And I want to also include the phrase tryouts to that, which would be tryouts, practices, and games.
And the court is not making any ruling at this point of moving children from any school or education at this point.
No, at this time, I would ask that the children remain in the school district that they are accustomed to. Anything else the parties think we need on this? We could set a presentation date.
That's what I was just about to ask, Your Honor. So what I will do, and just so Ms. Anderson knows, I will draft this, send it to you, and then we can always go back and forth to see if it accurately reflects what the court ruled today. And then we can come back if there's any disagreement on, I think I overheard next week is closed, correct, Your Honor?
Correct. Excuse me, correct.
What date would the court suggest?
Let's set this for July 25th at 1:00. It may be Judge Fassett on that docket, but I certainly could step on for presentation of this.
I did have one note on the phone calls. I wanted to clarify, you said the children will be allowed to speak with the other parent.
The non-custodial, yes, the parent that they're not with. Yes.
So allowed, but not required, because I've been getting repeated interrogative phone calls from their dad every day I have them. That's why I put in there that I wanted it to be every other day, because he's calling me on repeat every day I have them, including the day that I pick them up. So he's calling 3 hours
Well,
later.
I am going to require that if the children ask to speak to the non-custodial parent at the time, the parent they're not with, that yes, you are required to let them do that.
But it's not based on the parent calling. It's if the kids want to speak to their other parent, correct?
Well, I think we're splitting hairs here. I'm going to be
It's been a problem for a good month and a half or so that he's calling me on repeat, and I have repeatedly asked him to give me some time with my kids. I mean, he's calling me 3 hours after I pick them up.
So let's do this.
So here would be a suggestion, Your Honor. Why don't we do, if the kids want to talk to the other parent, they're allowed to call whenever they want to. But for the parents themselves, if they want to call and talk to the kids at night, can we just set a date or like a time each night?
That's exactly where I was going with this. So kiddos have unfettered access to the other parent should they ask for it. If the non-residential custodial parent at the time wants to talk to the kids, we're going to set a specific time of day. I would propose like 6 to 7 p.m. and they would be allowed to call the children once during that time frame. If you guys want a different time, feel free, but I would suggest one time a day during that 1 hour period, absent an emergency, of course.
Does it need to be every day I have the kids that he calls them? Because
Yes.
that's what he's doing for right now. Okay.
Yes, every day he
Okay.
is allowed to
Okay.
touch base with his children during the time that we've specified. I'm proposing 6 to 7 p.m. because that's probably before younger kiddos' bedtime, but feel free to adjust that time if the parties come to a different agreement.
Okay. Thank you.
We'll go ahead and put that in. And the same would go for Ms. Anderson as well. When the kids are with dad, she can call them every night. So I'll just make sure that that is in there. In the event, Your Honor, that we come to an agreement with whatever we prepared before the 25th, how does the court like to receive that? Should I send it to the judicial assistant? Have my assistant run it up in hard copy? How would the court like that to be presented early if need be?
So yes, if you want to, so you can do one of two things. For actual signature, you can send an email attachment to my judicial assistant, Sylvia Workala. And I can sign that order off docket. And then you would need to email the, what did you say, to civil domestic? Clerk domestic at the Cowlitz Superior Court, and they can strike the
Your Honor, and I don't see
presentation.
Ms. McGill online. I know that the last time we were before the court, she indicated that she would not be present at today's review hearing, that she was going to be on a plane. I guess the only thing that I would note is that at this juncture, she has complied with providing the attorney fee payments, the removal of her name from the child's bank account, the $5,000 deposited back into the bank account. The only thing that she hasn't complied with at this point is that she's not reimbursed my client the $33 for the rewards payment. I did on July 22nd, my assistant did on July 3rd. I'm sorry, did I say the 22nd? On July 2nd, I gave notice to her. On July 3rd, my assistant gave notice to her that we were still waiting for verification of the $33 payment so that we could strike this hearing. And she's not responded. My client has indicated he's not received that payment. So I would just suggest that the clerk's notes reflect that she's not complied with the purge requirements for paragraph 11C as far as that $33 payment.
Okay. And then would you want to set a review date again on this matter?
Yeah, we've got trials scheduled, and I think that's in October, and we can just address that at that time, so long as it's reflected in the clerk's minutes.
Okay. So we'll reflect in the court's notes that McLean is present on behalf of petitioner. Respondent is not present. The court did yesterday, it looks like, receive a satisfaction of judgment for some amounts, $1,800 and then a $5,000 amount. So that is in the file, but it looks like the outstanding issue is just a purge amount of $33 that remains outstanding. The parties can address that at trial in October. Does that sound correct to you, Ms. McLean?
Thank you.
Okay. We have a motion hearing to vacate default orders. Is that correct?
Yes,
Your Honor.
And then are we also, my digital file just closed. Hold on 1 minute. Well, it's not wanting to relaunch. Just a second. Okay. So I have the order to vacate default. And then it looked like there also, but correct me if I'm wrong, was an adequate cause motion. Is that correct?
Yes, it's right.
And I would just note that I'm assuming that the adequate cause was for purposes of maybe the motion to vacate the default. Otherwise, there was a motion for temporary orders that was filed by Mr. Larson.
That is correct, Your Honor.
And then Ms. McLean, you're stating there's also temporary orders submitted.
Yes, so I had received so Mr. Larson filed a motion to vacate the default, and in conjunction, a motion for temporary orders. And so we've responded to their proposed motion to vacate my client's default. And we've also responded to the motion for temporary orders, even though there isn't an order for leave of the court for Mr. Larson to file that.
Yes, Your Honor, we also filed a response to petition.
Sorry, go ahead. I didn't quite hear that response.
Oh, forgive me. We also filed a response to the petition.
Again, without leave of the court under CR 55-2C.
So I
Right.
think, yes,
55A2.
right. So I think first what we need to deal with, obviously, is the motion to vacate default. So Ms. Margraf, why don't you go ahead with regard to any oral argument on that motion?
Thank you, Your Honor. And to make this even more confusing, of course, we submitted materials to support the motion to vacate, as has been noted several times on this docket today. Finding legal representation in Cowlitz is exceedingly difficult. In fact, my client reached out to, my client's mother on his behalf reached out to Ms. McLean's office requesting assistance and was told she wasn't taking anybody at that time, as reflected in Elaine Larson's declaration. But essentially, we're asking that Mr. Larson did the very best he could to find representation as quickly as possible. And we're asking that the default order be vacated if for no other reason, the general disfavoring of orders entered on default basis, being preferred to hear it on the merits.
And Ms. McLean, I do have your response and memorandum of authorities. Any additional information you want to give the court?
Well, I would just indicate that even in Mr. Larson's reply documentation, he still provides no factual basis to support a claim that he has participated in or has shown good cause in order to vacate the default. Currently, he's not a party to this action. So while I recognize that counsel has prepared a response to the petition for him, he hasn't had leave of the court in order to do that. He does not explain why he didn't follow the plain language of the summons that was served on him. And when you couple that with the fact that his mother is a former family or dissolution legal assistant, clearly there were resources available to him. I can't speak to the veracity of his claim to having called my office. I don't answer my phones typically unless it's after hours. So I didn't speak with Ms. Larson or provide any information to that effect. Regardless, whether or not there was an attorney available at my office doesn't provide for excusable neglect on his part. The plain language of the summons tells him the website, tells him the time deadlines, tells him the form that he needs to fill out, tells him the clerk's office contact information, and he provides no factual basis for his failure to do any of that. My client has expended time and money as far as forwarding the default motion to the court in a timely manner. It was not on the 21st day, it was thereafter. This court has utilized time in reviewing the record and found that my client's motion for default was appropriate. So I would argue that at this point, there is no excusable neglect. There is no due diligence by Mr. Larson. And under the rules and the case law, the court should deny the motion to vacate. If, in fact, the court decides that it is appropriate to vacate, even though he's provided no factual basis, we are asking that the court enter a finding that my client has been prejudiced. One, because, again, he's not currently a party to this action, having been defaulted. Two, he's filed documentation with the court, both as far as a response to the petition, as well as a substantive motion in violation of CR 55A2, which then required my client to provide responsive documentation. So we're asking that the court award my client $1,800 in attorney's fees for having to respond due to his actions, again, contrary to the court rules.
Your Honor.
Go ahead.
This is true. Elaine Larson is a retired family law paralegal. No one knows better than Ms. Larson that she is absolutely in no position to offer any kind of legal advice or guidance to anybody else, and understood better than I'd say most of the folks in Washington State how important it was to retain legal representation for Mr. Larson. She was diligent in pursuing it. These folks are not from Cowlitz. The only connection Mr. Larson has with the county is the fact that his wife is from Kelso. She was starting over basically from scratch, reached out to a former employer per the materials we submitted, immediately attempted to follow up with local talent in Cowlitz, including Ms. McLean and Mr. Zandy, as a matter of fact, struck out there, had to move her search to Tacoma, found some people that stated they were able to and willing to appear in Southwest Washington, found out that was a dead end, and finally had to come to Vancouver to find someone. The consult didn't even occur until the day before the response was due. Mr. Larson felt that it was too important to respond with this documentation without an attorney. And he did everything he could to get this set up as soon as possible. As for submitting the rest of the response materials, the materials initially filed by Ms. Larson when she was a pro se litigant were incomplete and did not address various outstanding issues, including things like child support and a parenting plan. Mr. Larson, of course, is also reliant exclusively on a courier service to get all materials filed in Cowlitz, and thus, in the interest of efficiency, we decided to combine everything. And it was absolutely no sign of disrespect for the court, but merely an effort to keep things as streamlined and affordable as possible for my client. We are asking that our motion to vacate be granted and asking the court deny fees for Ms. Larson. Mr. Larson is absolutely incapable of paying anything right now in terms of legal fees.
So here's what I see from the file, and I do note that the original summons and proposed parenting plan, et cetera, were done pro se by Ms. Larson. I note that the motion and order for default were made on May 12th, and Judge Evans signed on that same date. That was also done pro se. I find that the notice of appearance from respondents' counsel was then made on June 12th, and the motion to vacate default, or excuse me, June 2nd. If I said June 12th, that's incorrect. June 2nd was made on June 2nd. I think in reading case law regarding default judgments and vacation of default judgments, I think I'm going to find that the respondent did very quickly and timely filed this motion, that the court is very aware that finding counsel for these matters can be time consuming and difficult. I do believe that taking counsel's statements as an officer of the court, that he was making efforts to seek counsel and respond. I will grant the motion to vacate the default judgment. The court prefers to have these matters decided on the merits. That said, though, I understand that Ms. McLean has expended attorney fees on behalf of her client through no fault or delay of her client in having to review and respond to this. So I will grant attorney fees to Ms. McLean. I think was the request $1,800.
Yes, Your Honor.
I will grant the request for attorney fees, but I will also grant the order to vacate default. And then my proposal would be, unless the parties want to do something different, my proposal would be that we would set a new hearing date for the temporary orders, unless the parties are asking to move forward on that today.
Your Honor, we're ready to move forward today, but I'd also like to note, Ms. Larson will have access to funds once the house is sold. She's not without resources. The marital home will have to be sold eventually. There's no way anybody can keep it.
I guess I would dispute that at this juncture. My client's intention is to maintain the home, which is where the child has known.
Okay. So here, and I'll just be bluntly honest with the parties, because the procedural history was somewhat confusing to me. I don't feel prepared to move forward today on giving you a ruling on the temporary orders. I would like to review the materials in more depth. I could set this on for next week if the parties would be available. That would give me more time to review the materials submitted and not just the default orders and the motion for adequate cause and vacation of default order.
So my difficulty is I start vacation on Friday this week, and I'm out until August 1. And the other difficulty is my client's need for some financial assistance.
Okay.
Your Honor, my client has covered every single bill in the house, save food, since the separation. That's mortgage, truck payment, car insurance, cell phone, utilities, minimum payments on the credit cards.
Okay. What if we do this then? I don't know if the two of you are available to stick around, I could call the other case, and then I can go off the record for a little bit and just review this material, and we'll come back on for argument.
I represent the father and
I can do that, Your
custodial
Honor.
parent,
Okay.
Cameron Gibson.
Okay, thank you.
These are our motions. Again, just for the court's reference, there is a presentation noted that's already on the calendar for next week for Judge Fassett.
Okay.
I'll note for the court, the children of this action are young. Genevieve is 4 and Isabel is 2-3 years old. This case unfortunately has a long history at this point with more than 200 case pleadings so far. The history is important, so I am going to detail some of it because even if the court read quite a bit, you probably didn't read all the way back. And so I'm just going to pare it down to the history that's most relevant to what's going on regarding first the restraining order. So in this case, originally the children were placed with the mother with significant time to the father, who was an active and involved parent. A critical provision was included in the prior parenting plan that the children were to have no contact whatsoever with the mother's boyfriend, Brian Rosales. That was in place because Mr. Rosales is a dangerous felon. He has prior domestic violence convictions in Superior Court. He has a prior finding of domestic violence regarding his own children. He has a prior assault 3 felony conviction. He has the records reflect that he struck his primary partner in the face with a closed fist multiple times. There are domestic violence protection orders between him and his last prior partner. And again, findings in his own parenting plan regarding his children of domestic violence, emotional or physical problem, and abuse of control. He has no contact with his own children. And this is why the court said he was to have no contact with the children of this action, because he was a dangerous person. From that order forward, for nearly or just past a year, the respondent mother denied the children having any contact repeatedly, said she had cut ties with this person or moved on. But the reality is those denials were just simply mistruths and lies, and several of them straight up. The children had contact with Mr. Rosales, and despite this, the respondent mother misrepresented, she lied, and she actively hid the truth from the court, from the guardian ad litem, from her own counselors and everyone else. In October of 2022, my client dropped off the children and shortly thereafter received a text from the respondent mother that said, "He's gone." And my client thought, that's odd. And what she meant to do was text Mr. Rosales that my client was gone. She did not mean to text my client. Video proof from a neighbor nearby would then show that shortly after my client dropped off the children and this text was sent, Mr. Rosales pulled up, picked up the mother and the children, and they then drove away. Text messages that had been previously filed with the court, which are voluminous, and the text messages and phone records are just the text and phone records between Mr. Rosales and the respondent mother, show hundreds, if not thousands, of communications over the last year, showing the depth and breadth of their relationship, that it was daily, it was continuing, and the information is that he resided largely with the respondent mother and the children, very much contrary to court order. When he was when the respondent mother was finally caught on video violating the court order and putting the children at risk, is when the court finally changed custody. I'll note that this came before the court with the children referencing things such as "we're not supposed to talk about Brian," and there was a significant level of control and authority exercised by the respondent mother over these very young children who were, I would argue, terrified to say anything. Children that age generally are going to let things slip unless they are very much motivated to not do so. And in this case, the respondent mother was able to do that and extort her own children to remain silent. From there, she was caught in October of 2022. The children, came out that the children had been repeatedly exposed, and we would argue almost daily exposed to Mr. Rosales. During the same period of time, just before October, the children were showing up, and it's included in the file, but quite a bit back. There's photos of the children with bruises on their faces. They're unexplained. The mother would refuse to put the children on video during video conferences. Again, the concern being that because Mr. Rosales is in the background, or the children were sporting other injuries. The court took exception and changed custody in October. Unfortunately, from there moving forward, the children have resided with my client. He's gotten them involved in counseling. They're doing very well. But my client is now tasked with unwinding from the children that they need to be secret keepers, and telling them that the truth matters, the truth is important, and that children are not to keep secrets, that's wrong. And that's something that the children really don't understand. And it's very difficult for them, having spent a year so carefully guarding themselves and keeping these secrets for their mother. On May 29th, Genevieve made a disclosure of sexual assault regarding Mr. Rosales. From there, my client took appropriate steps, contacting law enforcement, getting the child into counseling, getting the child scheduled for a CJAC interview. At the first CJAC interview, the child was reasonably not comfortable. This is a new process. She had never met these people. She did not make the same disclosure at the CJAC interview. She was then scheduled to begin very specific counseling that's aimed at young children. That began just, I believe, July 1st. So the child is now meeting with a counselor that has specialized training in counseling and working with young children who've been the victims of sexual assault. Child's already starting to make not disclosures of sexual assault, but disclosures regarding contact, including contact that occurred during the child being bathed, already with that counselor. A child subsequently made additional disclosures to my client and to others, and a second CJAC interview is being scheduled if that hasn't been scheduled already. Child is scheduled to remain in this really specific sort of targeted counseling through essentially mid-August. So it's not a long-term counseling situation. It's very specific and aimed at helping children who are in this unique position. So what we're asking the court to do with the restraining order is to maintain the current order, which has no contact for the respondent mother while this counseling continues and while the second CJAC interview can be conducted. The reason is that the mother was the one that made these children keep this secret for more than a year. Any contact reinforces secret keeping. Any contact allows the mother to be in this position where just her presence reaffirms that love means silence, that love means keeping secrets, that this is their job and something that they have to do. She exercised that power and control over them for a long period of time. And at this point, her presence in and of itself reinforces that prior behavior. And what the children need to do at this point is to just tell the truth, whatever that truth is what we're looking to do. So we're asking that the restraining order remain while the child finishes the specialized counseling. That's really not that long. It's scheduled to end essentially mid-August with a review expected August 18th. So that's just over a month. That's about 5 weeks out from where we are today, about 45 days. That allows the children to, again, work with the counselor, but without the pressure of the other parent who's asked them to keep secrets, and specifically keep secrets about Mr. Rosales. We then asked that the court set a review for August 29th, which is essentially the next available day regarding the restraining order. At that point, we'll have the counselor's report, which is an expert report. We should have a second CJAC interview. And we have the child who's been given sort of the grace and space to make whatever disclosures she's going to make. Again, these are very young children. Their process is not an adult process. It's not necessarily linear or easy for them. They are very much challenged with not the right tool set that we have, and certainly not the same communication tool set. So that's what we're asking as far as the restraining order. Not permanent at this point, but to give the child space to work through the process. Does the court want to address these one at a time, or would you like me to move on to my motion for contempt?
Let's do one at a time, since I think I can separate them fairly easily. So
Very good.
Ms. Gibson, your response to the request for an extension of the restraining order.
Thank you, Your Honor. I'm going to ask that the temporary order not be extended. As Ms. Baldwin indicated, this has been a long process with a lot of hearings and a lot of documents provided. There were some key dates when Ms. Baldwin detailed the history of this case that I feel are pertinent for you if you didn't have the opportunity to review them in the file. So I have been the girls' primary parent since they've been born. I was designated the primary parent until the hearing in November of 2022. I was assured by the GAL on our case that this was just temporary for the kids, and that, you know, we had a hearing set for February 7th of 2023 to address it. At that February 7th hearing, the GAL filed her final report, which named me as the primary parent. During that hearing, Ms. Baldwin alleged that they had continued video evidence of violence and yelling in front of my residence, and requested that the GAL report be pushed out and the investigation be continued. To date, that video has never been produced. So at a hearing where I should have been able to move forward and petition the court to get time back with my children, there was an allegation of evidence that has yet to be produced to any party to my knowledge. We did have a hearing on May 30th of this year, 23, which talked about the disclosure that she referenced and wanting to schedule the CJAC interview. But there was nothing in front of the court at that time to change the current parenting plan. Prior to this temporary order, I'm on supervised visits. I have been since November. The supervised visits are either with, we have 3 designated people. One is my sister, one is petitioner's father, and one is a very good friend of my family. So since November, I have not had time alone with the children. They've been supervised by these 3 individuals that have been agreed upon by the parties. So because Judge Fassett at that May 30th hearing stated that there was no change to the parenting plan because there was nothing in front of her to change that, that's when the ex parte order was signed. It was submitted and signed by a judge on June 2nd. That should have been heard 14 days from when it was signed. I believe that's the standard timeline. It got extended out to June 27th because we were already scheduled for a hearing that day. Okay, fine. By June 22nd, I hadn't heard anything from anyone. I hadn't heard from the police officer who had initially tried to reach out to me regarding the disclosure. I hadn't heard from the GAL. I hadn't heard from anyone. So I submitted a public records request to the Kelso Police Department to find out if the CJAC interview had taken place and what was going on with the file. The report that I received that I filed with the court indicated that the CJAC interview happened on June 5th. No disclosure was made at that time. So the officer informed petitioner that no disclosure was made and they were going to be closing their file. In that report, it's noted that Kelso PD closed their file the following day on June 6th. At the hearing we were just had a couple of weeks ago in front of Judge Fassett.
Hold on, Ms. Gibson. We just need to pause for a minute. Hold tight.
Yes, ma'am. Okay. So yes, I received that report from Kelso PD on June 22nd. I then filed it with the court the very next day on the 23rd, along with documentation from DC, which is my understanding of CPS, that their file is also closed, that they never even opened a file, that there were multiple intakes taken in regards to this disclosure by different people. You can see in where it states decision on all of those intakes that they were screened out, meaning a file was never opened because it was referred back to law enforcement. We had a hearing on June 27th, just 2 weeks ago, in which counsel indicated that I had filed some things late. I had only done that because I just received the documented information, but that she'd asked Judge Fassett to set it over to today's docket so that she had time to respond to the documents. The documents that I received, which weren't even filed with the court until this past Friday, July 7th, was that apparently there's another disclosure. And apparently that disclosure was made on June 14th. So nearly a month ago, that disclosure was made. There's no indication of it in any of this CPS file. There's no indication of it in the Kelso police file. Otherwise, I wouldn't have been able to obtain that report. Additionally, when I found that information out, I called back to the Kelso Police Department and filed on Monday. So I don't know if you received a copy of this or not. I tried to get it to you.
Yes, your email with the police department.
Yes. Yeah. So I followed up with Kelso PD, thinking that there might be something added because this alleged disclosure happened almost a month ago. And they indicated to me that there was nothing new added to the file. So it's just really alarming that petitioner and his mother in these declarations are alleging that another disclosure happened and it's not in any of these files. That's very alarming to me. And that Ms. Baldwin didn't bring that up during the hearing 2 weeks ago. Her indication was we need time to respond, not, oh my gosh, there was this other allegation that needs to be addressed and heard. So we're at this hearing today, which is 40 days since the ex parte order was signed on June 2nd. 40 days, Your Honor. I haven't seen my children at this point in almost 2 months. The temporary order was only supposed to be until the CJAC interview was conducted. The interview was conducted the next business day on the 5th after the order was signed. No disclosure was made, and all of the files from everything I've been able to obtain are closed. There was no finding, and it's done. Both counsel and the GAL stated that this CJAC interview needed to be done to see and confirm if anything happened. The CJAC interviewers, from my understanding, are trained specifically in this field to find out the truth. And the truth is she made no disclosure. Nothing happened and the files are closed. So now I'm flabbergasted, Your Honor, because I was told that this CJAC interview would be the definitive thing, that yes, something happened or no, we didn't, so it could move on. And now it's, well, nothing happened this time, and now we need all of these other things to happen. It's also through reading petitioner's declaration filed on July 7th. This is the first time I'm hearing that my daughter is seeing a new counselor. To my knowledge, this temporary no contact order doesn't change our just joint decision-making that's currently as the rest of our temporary plan. So the fact that I was never notified by anyone that my daughter is now seeing this other provider is not okay either. I would just say that it's in the best interest of the children to have contact with me. As I stated, until November of 22, I was their primary caregiver. Since birth, I took care of them all of the time since petitioner worked so much. And due to this ex parte order being signed, I missed my preschooler's graduation as well as her 5th birthday. She just recently turned 5. I couldn't contact her on her birthday to reach out and wish her a happy birthday. My family also tried to reach out, and to my knowledge, didn't receive any sort of response from petitioner. So no one in my family was able to call her and wish her a happy birthday. I made a mistake back in November. I've recognized and acknowledged that to the court. I followed all of the court recommendations since then, and I've been on supervised visits. As I've stated, half of those supervised visits are with petitioners' families. My supervisors have submitted declarations to the court stating that they'll sign anything necessary. I'm not on unsupervised time. Nothing has happened. There have been no disclosures for any of the time that I've been on these supervised visits. So I don't believe there's any reason to allow the no contact order to continue. It's been, even just since the order was signed, it's been 40 days, and I'm just now being able to be heard on this matter.
Okay.
My children need their mother in their life, and I'm asking for the supervised visits to be returned.
All right. Thank you, Ms. Gibson. Ms. Gravina, are you here to give input on this issue or the contempt issue, or both?
A little of everything, I think, Your Honor, but I think my concern extends a little bit further back, as Ms. Baldwin kind of addressed. While in some cases I would agree with Ms. Gibson, and she is right in some of her aspects, what I would say is that when this matter was brought forward, when Ms. Gibson was discovered to have Mr. Rosales around the children, the concern had been about the dishonesty and the lying, and mother very blatantly lied not only to me but to the court, and when caught in the situation then was able to finally admit, but there was some significant concern and there was some significant growth that the court had kind of placed on mom's shoulders to expect her to step up to the plate and show that she was making changes and that she could be trusted and that this was a priority for her. And at first it did appear that way, which is when I put out my additional information saying that it does appear, or that I was at that place where I put out the report and say it does appear mom did address these things. This is where everything is at. And then that weekend or that week was contacted and said, there's some concern. There was an altercation. Mother's contention was that she had a pipe burst and had only the ability to contact him. No other family members were available. She had tried a number of people. The city had already closed. It was too late on a Friday. And mother had indicated repeatedly that there was not an ongoing relationship. And father and Ms. Baldwin had addressed to the court that there was some pretty significant concern about mother lying specifically about this in the past, and that there was an inability to trust that she was not continuing that relationship and what that would look like for the girls if they were to return to her care, and mother can't be trusted. The court did ask that I investigate specifically for that. As that progressed and as discovery was ongoing throughout that, there were a number of conversations between mother and I, specifically regarding the contact. Mother repeatedly indicated that no, there was, initially a couple of conversations right when the matter happened in October where she broke up and he had to get his, few things that he had at the home. And then there was nothing further. Mother reiterated that to me several times. No, there was only that call. And then the one call where I had to have him come over and help me fix the pipe. There will not be any more than those 2 instances on those particular days. I indicated to mother that the court was specifically asking if mother was being honest, and that was the standard that the court had asked me to investigate, and whether that reflected in the messages and in the discovery and in subsequent information throughout that period. At one point I received records from mother. Father indicated that he didn't believe those were accurate records. There were misspellings. There was, the records just looked a little funky. And father had expressed concern and asked that I wait and not formulate my opinion, but that they were going to subpoena the records. The records came and there were dozens per page of calls missing. And when addressing the issue with mother and discussing, hey, these records don't match up, mother's indication was, well, I don't understand why they're missing all of those. And I specifically asked mom, even if they didn't match, when you indicated to me that you were not continuing to talk to him, you would know whether you did or not. I feel like the dishonesty means that I'm struggling to believe the things you say. Within, I think, 48 hours of reviewing those records was also the disclosure. And so those conversations at the same time gave me a significant rise to concern. Mother in that conversation also indicated there were not times where Mr. Rosales was around the children. The children have continued to say that that's not accurate. It is now becoming more and more difficult to believe mother's report on those things when mother blatantly lies, and the children are saying that mother blatantly lies and tells them to lie. And I have, because of those records, already had concern and was ready to address with the court that there was concern about mother's ability to report honestly, and that mother's willingness to protect against Mr. Rosales, and that she was unwilling to be honest about his presence in her and the children's lives, gave rise to concern for continued contact, and what a recommendation for time would that look like at that point. And then with the disclosure is a significant hesitancy to believe how mom reports she's discussing things with the girls, how mom is saying, well, I've never told the girls to lie, but the girls repeatedly say, mommy said to lie. Mommy, they are continuing to say this to father, apparently to counselors, although I have not heard back from the counselor yet. So when I brought this up with mom, mother's contention is that Mr. Rosales did not have contact alone with, So when I brought this up with mom, mother's contention is that Mr. Rosales did not have contact alone with the children. However, in a transcribe where Mr. Rosales made a call to father, the transcribe, he admits regularly being alone with the girls and even caring for them while mom was not present and things like that. And so there is a significant level of understanding whether there will be accurate disclosure if mother has been or continues to encourage these types of conversations where they're not allowed to talk, or they are told to lie, or they believe that even if mother hasn't. They're reporting that that's how they feel about the situation, and they have definitely felt unheard about Mr. Rosales and not believed throughout this time by being told, no, that's not accurate. He's not still there. You're not still seeing him. But then a year into this, that turned out to not be the case. And so my level of concern, even for myself, I have a concern that it's beyond my scope and role to even go interview the children when there are professionals that are trained to do this and they should be the ones doing it. I am even hesitant to go meet with the girls until the professionals have completed their investigation and have a recommendation. I have not received any calls back from CPS yet, so I don't have that information to update, although I did see mother's documentation. I just have not verified anything further, or if there's anything going on or ongoing, I mean. So I do have levels of concern. I am hesitant to believe almost anything mom reports at this point. There have been numerous incidences over the course of this investigation where mother has just blatantly made things up and found to be not the case later on, and to the point where the girls have now been put at risk. And the concern is the unwillingness to protect, or the failure to protect from that individual. And on top of that, the encouragement to lie or keep secrets.
Thank you. I appreciate that input. My decision on extension of the restraining order is this. I am going to extend the restraining order through the date the court can next review this, most closely following what we think will be the end of counseling. I believe that date is August 29th, 2023 at 1 o'clock. My reason for this is I do believe, based on the pleadings, the reason for initially imposing the restraining order still apply. I do feel as though more likely than not, we do need to protect the child further at this point, while potentially either a second CJAC interview is being conducted or has recently been conducted, and further discussions with a counselor will be had. I take into account the age of the minor, which, based on my training and experience, does tell me that it could take some time for a child to be comfortable with a counselor or other adults before truly opening up. So I think this is warranted, given the allegations and given the documentation of credibility issues with respondent in this case. So I am
Next
going
issue
to sign
is
that
the motion for
order.
contempt. The motion for contempt is pretty straightforward and clear cut. The obligations of child support include the actual transfer payment, but they also include payments on daycare expenses. Both parties owe a percentage share of the daycare cost. My client advances the cost at 100%, and then Mrs. is obligated to pay 40% of that total cost to him. I'll note, this is not our first contempt regarding financial misdealings regarding the respondent. There's a prior contempt from April 11th of this year, also regarding financial issues. In this case, the issue is specifically regarding those daycare costs. Those costs were incurred. No one disputes that. The bills were timely forwarded. No one disputes that. And the respondent has not paid, except she made I think $350 has been her total payment. Her entirety of her argument is simply the argument for an offset, which is not appropriate. Child support is a completely independent obligation from any other obligation. There is no ability to self-help in any way. And that is essentially what she is arguing about. That's not appropriate. She's arguing for an offset. And even if you were to delve into that argument, which I don't think you should, essentially her prior attorney wrote that she was obligated to pay the mortgage, which does include, and everyone agrees it includes, the taxes and insurance. And then below that, put that my client was obligated to pay, I believe, the taxes on the real property home that Mrs. is residing in. I would argue that's an ambiguity. That is a confusion, as we know from contract law, that's construed against the drafter, and the drafter in this case was Ms. Gibson and her attorney at that time. So an offset is not ever appropriate in child support, but even as it was in this case, you just don't rise to that. The next argument she attempts to make is essentially that, well, gee, I can't afford it. There's no evidence in the record of that either. She doesn't provide any financial declaration, no budget, no expenses, just sort of a bold-faced, I can't pay, so I'm not going to. I'm going to pay what I want to. The reality is these children have expenses. They are very real, they're very present, and they're required. My client needs for the children to be in childcare just like they were in childcare previously when they were in mother's care, and my client paid. It's this shoes on the other foot, and Mrs. is saying, I'm just not going to do it. I'm not going to pay, and you can't make me kind of a situation, and that's not appropriate. So in this case, other than I said, she's made about $350 worth of payments since October. But at this point, the total arrears is approaching $5,000, $4,690 through the date of filing of the contempt. She also is obligated to pay 12% interest on that. That's statutory. We are asking for fees of $3,500. This is a long-term refusal. Efforts have been made to get her to comply. She's just ignoring them. That's not appropriate. A sanction of $1,000 and cost of $75. That's essentially service fees and ex parte filing fees. In this case, absent payment, the children really are very much in danger of losing their daycare position, because my client just can't do it all. He cannot front the entire cost permanently, fronting essentially mother's court order responsibility. The prior child support order outlines mother's income at $3,300 per month net. She has a reduced child support obligation of $552. She has more than $2,700 per month to pay and make her bills. You notice that absent from her declaration is any statements on any efforts whatsoever to reduce costs in her household. She doesn't say, I've cut my cable, I'm eating beans and rice, I'm doing everything cheap, I'm not wearing makeup. She hasn't cut a single expense. It's just, I'm not going to pay because kids are with Mr. and I think I can get away with not doing it. That's not appropriate. Again, this is the child's right to receive support, and mother is ignoring the things that are necessary for the children and their world. We're asking the court to find contempt, order the arrears, and the fees and penalties that we've outlined. Additionally, the court should set a review and a amount certain that mother has to pay towards the arrears to bring herself current.
Ms. Gibson, I do have your responsive pleading on this issue. And I am going to let you make argument to me as Ms. Baldwin did. I just want to clarify, I believe you've acknowledged in your response that you have not paid the 40% towards the expenses. Is that correct?
I have been paying towards it, Your Honor. I do just want to say at the hearing 2 weeks ago, the indication that I received was that this was going to be heard by Judge Fassett next week. My responsive declaration in regards to this, I omitted a bunch of information because this has already been litigated and talked about before Judge Scudder and Judge Fassett. So I omitted some information that I've provided in previous declarations because my understanding was this was going to be heard in front of Judge Fassett. So I'm not fully prepared to argue this today. However, if you need me to, I will do my best. But my understanding from the hearing 2 weeks ago was that this was pushed to Judge Fassett's docket next week.
Are you, you do have a presentation in front of Judge Fassett regarding the sale of the home, which was set to July 18th at 1 o'clock. Are
Yeah.
you, the court notes I have state the court sets child issues and restraining order to today, July 11th.
That'd be correct. I think this is the actual show cause date. So this was set via the show cause. I don't believe it was on last week or last time this was before the court. I believe this was the show cause date that was originally set. And then I essentially said, well, Judge, we're already on. Mrs. was given the option to put the restraining order over to have Judge Fassett hear it next week. When she returned, she said, no, I want to have it heard. This is the first time this is being heard. It's appropriate that we go forward today. Everyone submitted their responses today. There's nothing more to be submitted at this point. So I think it's appropriate that we move forward. And I would disagree that the issue of contempt on child support has been raised previously.
Okay. And I'm just digging into this a little further. So let me clarify, Ms. Gibson, are you planning to submit additional evidence to the court regarding the contempt issue?
The responsive declaration and the financial declaration that I filed on July 6th was based on my understanding that this was going to be heard next week by Judge Fassett, who has already previously ruled on issues that are related to this contempt that she had to look over from when Judge Scudder was our initial judge. Had I known that this was going to be before you today, I would have filed a completely different declaration to outline and explain some of that, but I didn't, based on my understanding that Judge Fassett was hearing all of this and she's previously heard some continued issues regarding payments of bills for both parties.
Yeah, and I think here might lie the confusion. And, Ms. Gibson, I understand you are unrepresented. In one instance, when you all were in front of Judge Fassett on June 27th, the notes, the typed up clerk's notes do reflect that, quote, court sets child issues and restraining order to July 11 at 1 o'clock. Presentation of order regarding sale of home set to July 18 at 1 o'clock. But then down below, it does indicate on July 18, 2023, 1 o'clock, show cause contempt, Judge Fassett, July 18, 2023, 1 o'clock, presentation of order. So I think there might be some confusion. I guess what I would say is I understand Ms. Gibson's confusion on whether the show cause contempt was going to be addressed today versus heard by Judge Fassett, who has already heard some of this case. So I think what I'm going to do, given what Ms. Gibson has stated to me just now, and my review of the notes that do show July 18th for show cause contempt, I think I'm going to give Ms. Gibson the benefit of the doubt and just move this specific show cause contempt issue to next week, July 18th, since you're apparently already set for that.
And just for the court's reference,
Yes.
the only reason it appears, that's the alternate date. So that's why it shows.
Okay.
So she was served timely for today, and we always set them so there's the initial date. But if you don't serve correctly or get it served in the right amount of time, there's always an alternate date. So that's why it appears on the court's calendar next week.
Gotcha. And I guess I'll ask you, Ms. Baldwin, do you have a strong objection to setting this over 1 week for Judge Fassett to handle?
Only if I understand the court's concern. I would just ask to reserve fees. We're here. I basically made argument. She listens to my argument and then says, oh, I should have filed a bunch of things. And now is going to have a week to file things that now are not going to conform with the local court rules. So that would sort of be my concern.
Yep. So I think I'll make the record clear that if there's additional attorney fees, let us, for sake of argument, if we assume that this motion is ultimately granted and attorney fees entered, certainly the court would entertain the additional attorney fees for essentially re-argument in 1 week, which I think is appropriate.
Okay. Very good. If the court would just make sure that that's in the clerk's minutes, then we could address it with Judge Fassett.
And I'll make sure I'll send a follow-up email.
The only thing is I do
Judge
have one
Fassett
preliminary
to position
objection
us
is that I'm
where
asking that you not consider the declaration filed by Elaine Larson. It looks like that was filed on July 6th. One, because it exceeds local rule 88C2 as far as page lengths. There's been 2 declarations submitted in SIR reply. Mr. Larson's declaration of 4 pages with attachments and then his mother's declaration of 4 pages with attachments. So I just simply ask that you not consider the one from his mother.
Your Honor, that's directly relevant to claims made about whether or not this was done with any kind of speed, and also offers several refutations to some allegations that sprang up newly from the latest reply declaration from Ms. Larson. We ask that this be allowed to remain.
Okay,
And I would just,
go ahead. And we're talking about the July 6, 2023 declaration of Elaine Larson.
yes.
Yes, Your Honor.
And I would just note that local rule 88 C2 provides that reply declarations are limited to 4 pages in total. And there's been no motion filed or leave of the court to extend that page length. I would also note that the reply declarations of both Mr. Larson and his mother provide new information that my client hasn't had an opportunity to respond to.
Declarations were in response to new allegations contained in the reply declaration and the third-party declaration submitted on behalf of Ms. Larson, and one of which I believe is actually too long. I believe third-party supporting declarations are supposed to be 4 pages in length. And Jessica, I can't remember her last name, I believe hers was 5 pages in length.
Okay, I'll take a look at that and when we come back on, we'll address that first.
Thank you.
Thank you, Your Honor.
Thank you. I wasn't looking at my Zoom screen to see that you both were back. Okay, so let's first address, I think, the declaration of Elaine Larson. What I'm going to do on this one is, although I think I will consider just the 4 pages of the actual declaration without reference to the exhibits. And then I think it complies with the local rule, the local rule. I think that the supplemental declaration of Ryan Larson does arguably relate to some new, potentially new allegations. I'll give a little leeway on that. And then I think, Ms. Margraf, you had some concern with the declaration of Jessica Barron. Is that correct?
Yes, Your Honor, local court rule states that they need to be 4 pages in length. And furthermore, 88B states that all supporting declarations should be filed with the petition and not a reply declaration, if I'm reading it correctly.
Yeah. And I think just what I'm going to do on this, similar to some of the leeway I've given on respondents' declarations, is just that I think given the unique posture of this case, I am going to allow the declaration of Jessica Barron as is. I think that given the default and the motion to vacate default and those sorts of things, I am going to find good cause to allow it. So I want to move on to the temporary orders. And I have original orders as proposed by Ms. McLean, but I do also have digital copies of a proposed child support worksheet on behalf of respondents. Okay. So then I do also from June 2nd have proposed orders in a digital file that we'll use for comparison for a temporary parenting plan, proposed child support worksheet. And I think that's it.
Your Honor, if I may.
Go ahead.
The latest child support worksheets from us do incorporate the new information we have from the most recent filings for the pay stubs for our client, just to clarify.
And I was going to ask that. So let's get to that in a minute. First, I'm going to address Ms. McLean's proposed order appointing guardian ad litem for child. Ms. Margraf, are you objecting to the appointment of a GAL?
Well, no, since we requested it. However, I would like to go over the proportional split proposed. The reason we asked for the GAL was due to the nature of the allegations, and especially in the requests for 3A and 3B restrictions on my client. We think they're unsubstantiated. We were concerned it was going to interfere with his ability to spend time with his child and to participate in decision-making. So we would ask that it would be a 50-50 split. And we'd also ask for the county to pay his portion. I think our filings have shown that Mr. Larson has extremely limited means considering his obligations at this time.
Okay. So first, I'll get to those issues, and Ms. McLean, I'll have you chime in as well. But first, let's pick the GAL report. Let's go to payment of fees. The proposal I have in front of me is private pay within 2 weeks, 78% paid by respondent, county pay 22% paid, county expense on behalf of petitioner. Ms. Margraf, it seems like you want to discuss that, so go ahead.
Thank you, Your Honor. Well, as noted a moment ago, we requested a guardian ad litem because of allegations that my client abandoned, neglected, and abused his child, none of which obviously we think occurred. Otherwise, we would not have requested it. We don't think the materials submitted would substantiate such a request just as standalone, but we were concerned and out of an abundance of conscience, we wanted to avoid any possibility of interference with parenting time because this was a request based on, again, allegations made by Ms. Larson. We would ask that the proportional split be actually 50-50 rather than the 78-22.
Ms. McLean?
Thank you, Your Honor. First off, typically the court allocates those percentages based upon the factual financial findings relative to the parties' incomes. Currently, my client is receiving Social Security for herself as well as the dependent benefit for the child. Under case law, you would include the child's dependent benefit as income to my client for purposes of child support. So that's how I arrived at the gross of $1,879.30 and a net of $1,806. Mr. Larson, quite frankly, is attempting to somewhat, how do I want to say this? Attempting to misalign his income. If you take a look at the sealed financial source documents that he filed back on July 6th,
Yes.
look at the first wage stub. The first wage stub is dated March, well, it's a pay period of March 31. And you'll see on the upper left-hand corner, there's a regular hourly rate of $18.74.
Yes.
Go to the last document in that filing. It's dated a pay date of June 23. And you'll note that his rate now, because his position has changed as district manager, his pay rate is now basically calculated as a specific rate of $2,307.69 for 80 hours. And that equates to, I have to go back to my notes, bear with me just a minute, $28 and, bear with me, $28.85 per hour. So he's received a $10 per hour increase. And this doesn't even include what you see identified as holiday pay, paid time off, retro pay, and then his incentive, his sales incentive pay and his sales incentive overtime pay. When you add those in, so if you take his straight wage, hourly wage at $28.85 an hour, 40 hours a week, that means he's grossing $5,000 a month just on that pay alone. When you add in his holiday time, paid time off, retro pay, the sales incentive overtime, the sales incentive, and his sick leave, that's an additional $14,737 in the last 13 pay periods, or an additional $2,456 a month gross. So his gross pay right now is $7,456 per month when you take into consideration his $10 per hour pay raise that he's just received. If you take what council is suggesting through their submissions and through their calculations, is that you should use the year-to-date totals. The year-to-date totals depress his income because up until, and again, go back through the documentation that they've provided, up until May 12th, the May 12th, 23 wage stub shows that he's still at that $18.74 per hour wage. And then it shows for the first time 40 hours at that $2,307.69 flat pay. So they're trying to depress this for the first 4.5 months of pay. So the reality is that his gross is $7,456 per month. I calculate his net on that figure alone at $5,811.77, which would put him at 76%, would put my client at 24%, and his child support obligation under those figures would be $939.25 a month. So I would propose, first off, my client, if there's anybody that's limited, it's my client. She's limited to what Social Security is willing to pay her for her disability and to pay for the child as her dependent. In regards to Mr. Larson, he certainly has discretionary spending. He had enough money to make the decision to sell a vehicle or to trade in a vehicle that was free and clear and incur a vehicle payment that he didn't need. And he's provided absolutely no proof that there was anything wrong with that vehicle necessitating that purchase. So he should be required to provide payment to the GAL at 76%. And then the adjustment for my client through county pay at the 24% would be $720. So if you would limit, instead of $660, it would be $720 paid by the county and $2,280 paid by Mr. Larson.
And Ms. Margraf, and this is a bit of a crossover into the child support worksheet, but that was a question I had. I mean, certainly if I use his year-to-date total, it comes closer to the figures that you're proposing in the worksheet. But I do note a recent increase in pay, which bumps up his gross over 7,000 and net a little above 5,000. What can you or your client tell me about that?
Well, what I can say actually is when you do look at the pay stub dated 6/23/23, and you see the kick over into a salary position, he still has a net pay of $1,900 essentially. Furthermore, the incentives, as we can see just from looking at this very wildly, sometimes it's $550, sometimes it's $1,900. It's very unreliable. But just taking this, if he's being paid a net of $1,904 times what, twice a month. Hold on just a second, please. If we take $2,307.69 times it by 2, that's $4,615.38 times 0.8 to take out a reasonable 20% for taxes. I'm getting $3,692.30 for net, just for a salary bill. And again, with the
Is he
with the
paid,
supplementary pay.
is he paid just twice a month, or is he paid every 2 weeks?
He's paid every 2 weeks, I think.
Okay, so then there's 2 months in there where he'd get 3 checks then.
Okay.
There would be 4 months that he would get. I think there would be 4 third or 3 pay periods in a month, or there's for a year.
26 pay periods in a year if he was paid every other week. That'd be 2 extra checks.
Yeah, it's 2 extra
I'm
checks.
with you.
Yes,
Right. That is correct.
So 2,307.69, and let's say 26 checks, and then we're going to divide that by 12. Yeah, for me, that's still, I don't quite get to that. I don't get to that $7,000 figure, even at this higher rate.
May also be heard, though, as far as, first off, some of the deductions that council's using when she's using the net that's on the pay stub are not allowable deductions.
Yeah, and that's fine. I'm just going off gross right now to calculate a gross monthly wage.
So even look at his year-end wage stub for 2022 that was filed back on June 2nd. It's the very first page under the sealed financial source, and actually, I think it's the second page. No, actually, it'd be the third page. So
Okay, let me get there. Yep, I see that third page. Mhm.
Okay, so if you look at his sales incentive, there's $28,026.66, and then his overtime is $876.27. So that gives you an idea as far as what the year is. And again, that's $2,408 a year just on sales incentives, in addition to his gross wage. Based on what he's done year to date for 13 pay periods in 2023, it's $2,456. So it's $48 off what he did the entire year last year on an average month.
And you're looking at the period beginning 12/21/2022, is that right?
I'm looking at the third wage stub in that sealed financial source document with a pay date of 12/23/22. The 12/21/22 is, well, I guess, yes, technically they're both the same. He gets paid a different paycheck for his sales incentives versus his hourly pay.
Right.
So he gets 2 wage stubs either each pay period, or else they might do the sales incentives maybe once a month. But in any event, those average out. For last year, the average was $2,408 a month. And so far this year, it's $2,456 a month. And then if you take his current hourly, and that doesn't include his overtime, his sick leave time, all of the other pay items that you see on his wage stub, just his hourly at $28.85 times 40 hours times 52 weeks is $60,008. And you divide that by 12, and it's $5,000 a month gross. So when you add that with his sales incentives, we're at $74.56 right now.
So I'm looking here at the third pay stub, the 12/21/2022. I have a gross, and first I'm just going to look at gross pay. So his gross pay year to date is $67,905.01, which does include a $3,052.46 sales incentive. It's included in that year to date total.
You understand that? Turn to the next page though, because the next page is his actual year end total wages. That shows $69,434 when he's making $10 and what would that be? $10.50 an hour less.
So I'm going to use that number now because I'm not getting anything close to $7,000 a month with all of this. That would be gross $57,86.17, and that does include sales incentives for the entire year of $28,000, which then when I go back to the July 6th pay stubs, and let's just go to the last one. And if we use year to date of 35,510.01, and that's for 6.5 months of the year, that's $5,463.08.
But
I
again,
think those numbers come out very close to each other and don't get me up to a $7,000 or $8,000 figure as your client is proposing.
Also, we would argue that so far, halfway through the year, we're at $11,000 for sale incentives. So whether or not he's on salary or on wage, it's reasonable to assume that he's not going to do much better than double that for the year-to-date total in December.
Well, and I guess here's what I'm saying too, is the sales incentive is part of the year to date that I'm using. So he's had year to date, he's had $20,000+ regular. He's had a little bit of overtime, some holiday, couple $100 of retro pay and paid time off. And then the sales incentive is $11,000 of that income. So the regular pay and the sales incentives and some smatterings of other items equal $35,510.01 for 6.5 months. When you divide that over 6.5 months, you arrive at just over $5,000.
But again, Your Honor, the first 5.5 months of that is at $7 or $18 an hour, and now he's earning $28 an hour. So look at his last wage stub for dated June 23. If you take that figure of $2307.69, because that's a full 2 weeks pay, take $2307.69 times 26 pay periods in a year.
Mm-hmm.
That equals $59,999.94.
Yes.
Divide that by 12, it's $4,999.95 on his regular pay alone. That does not include his incentive pay. So you have to add the incentive pay on top of that. And counsel's suggestion that, well, the assumption is that he's not going to make more than double that $11,000 figure that's on there. Again, one of the prime times for sales is the holidays. The holidays haven't even happened as far as Christmas. So that argument, I would suggest, falls flat when you look at this industry and what his current wages are. Since he filed this action, he's getting almost a third more income on his hourly wage, because he's gone from, in May, he was at $18.74 an hour, and now he's at $28.85 an hour.
Okay. Here's what I'm going to do on his wages. We could go back and forth on this all day. I think some of this will probably come out in trial. Ms. McLean, I understand your argument about a raise just in the last month, couple of months, essentially. So the balance I'm going to strike here is that when I calculate his the new hourly rate, assuming full-time work, that gets you at the $4,999.96 per month in regular pay. His sales incentive, I understand, can vary significantly, but year to date, we have $11,211.90. I'm going to double that amount for the year, which is not that far off from what he did last year. And I certainly, I can't sit here and predict that he's going to make more or less in sales incentives. Sales are up and down depending on a lot of factors. So I am going to I'm going to impute to him double his sales incentive from his last pay stub. So that'll be $22,412.
Are you considering the sales incentive overtime as well, which is the $321.18, or not?
No, his total sales incentive is going to be imputed based on the evidence in front of me at $22,423.80. When I divide that by 12 months, that is on average an extra $1,868.65 per month. So I'm going to impute to him a total gross wage of $6,868.61. Larson's income is very concrete and measurable at gross at $1,879.30. So then in comparing those two numbers, that will be I do believe respondent should be responsible for private pay of his portion. The county will be responsible for for Ms. Larson's portion. So I think that'll change the numbers a little bit.
It turns it to 75% versus 25%. I have a net for him of $5,398.54. And then of course my client's net, and then a child support obligation for him would be $887.57.
Okay. That would be my ruling. If the parties want to put any objections to those numbers on the record.
You're welcome. And so 75% and 25. And then his obligation would be $887.57. And of course, hers would be $297.43, but hers would be consumed by the dependent spinoff benefit.
So I have made those changes on your proposed order, and I'm going to initial them and sign this today.
Sure. I mean, as far as the, so as far as, do you want to hear parenting plan, or do you just want to stick on financials for now?
Whatever order you want to take them at this point. I know
I guess
we're here a really long time.
Let's stick on financials.
Okay, perfect.
So we figured out what his wage is, and based upon my client's limited income, we are asking that the court award her $2,000 per month spousal support effective June 1 of 2023. My client has provided her financial declaration to the court, and her monthly expenses are currently $5,640 per month. And that assumes that she's paying the home mortgage of $1,909, her car payment of $235, which was in existence before this matter was even filed. She has credit card payments of about $300 per month. And then Social Security deducts for her health insurance. And I'm not sure if that covers it or not as well, but in any event, her health insurance at $164. We are asking that Mr. Larson continue to maintain my client and the child on his health insurance on a monthly basis. And so in order to meet her monthly need, at least come close to that, we're asking for the $2,000 per month spousal support. These parties have been married for the last 9 years. They do have one child born as issue of that marriage, and that's Ryan, and everybody refers to her as Rue, as Rue. Rue is currently 6 years old, and so we're asking that my client have sufficient money within her household in order to provide for her and the child. My client and the child continue to reside in the family household. If you provide her with the $2,000 per month, and technically I calculated as far as child support at $939, so what I said is now $885, I think is what I said. Oh, I still have that open. If you adopt the $887 a month, then that would give her $4,693 available within her household to cover those expenses, as well as meet the child's expenses. Given your current finding of sorry, I'm having to do these calculations on the fly.
Yes.
Given your current ruling with his net at $53.98, if you order the $2,000 a month in spousal maintenance, the $887 in child support, that leaves him with $2,511 to provide for himself as far as his expenses. And keep in mind that your calculation of his income has not taken into consideration his additional overtime, the incentive, sales incentive overtime. It is not taken into consideration his holiday pay, his paid time off, his retro pay, or his sick leave. And so we think that that's appropriate given the 2-household family for my client and the 1-household family for Mr. Larson's current situation.
Ms. Margraf, I'll turn it over to you, and specifically spousal support.
Thank you, Your Honor. With that new net of $53.98, and I would say that we should exclude things like paid time off, holiday pay. That's not going to be something monthly and substantive. Furthermore, the ruling was that the amount earned so far for incentives doubled should suffice. And I'd also note that the other overtime incentive was under $350 so far for 2023, and in my opinion, de minimis. We still have a situation where Mr. Larson's expenses so far every month are $6,452. I understand that Ms. Larson is proposing the parties actually split the cost of the mortgage going forward, which would save him $900 a month, but he's still paying over $1,000 a month for his lodgings in Lake Stevens. I'm assuming that by asking for $2,000 a month, she's also going to be taking over the payment for the car, the credit cards he's been paying, the utilities at the house, the cell phone bills, all of that. But nonetheless, leaving my client with $2,511 a month net to live on is completely unreasonable. There's simply absolutely no room for spousal maintenance in my client's budget. We just filed the financial declaration outlining what his expenses look like every month. I mean, even with everything else taken into consideration, I'd also like to address the allegations about the vehicle he's driving. He had to replace the vehicle he had from before because of damage caused by some incidences with Ms. Larson driving, as far as I'm aware. Furthermore, it's a 4-year-old base model crossover Ford SUV. It's hardly a nice vehicle. I mean, it's just a very run-of-the-mill vehicle. And I don't believe people who are on salary receive overtime, period. I don't think that's going to be available going forward for Mr. Larson.
Yeah, I mean, I think we've made a very reasonable ruling on his income, given the lack of a surety of sales, the de minimis overtime and holiday pay. So I'm not overly concerned with that. I guess what I want to dive into a little bit is, because I think my ruling on spousal maintenance will somewhat depend on how some of these debts are split up. So the home mortgage that Ms. McLean, the 1909 that you're proposing petitioner pay, provided spousal maintenance is paid.
Yeah.
Is that half of the mortgage?
No. So the proposal would, I mean, obviously, these folks are going to be separated, and the intention is to try and segregate debts to them as much as we can now. Taking into consideration the fact that this is a community residence, but the mother and the child are living there, then the expectation would be that she would be paying the $1,909 per month, and that's the basis for her financial need and request for spousal maintenance. I have provided in there that she's responsible for making that payment, provided he's paying her spousal maintenance. I've had situations in the past where my client was ordered to pay the mortgage. The opposing party was ordered to pay spousal maintenance. the opposing party didn't pay the spousal maintenance, and therefore my client couldn't pay the mortgage payment, and there were contempt motions filed relative to that. So I typically provide for that caveat that would couch such that my client's responsibility is so long as the opposing party remains compliant and current with their spousal maintenance obligations.
Your Honor, my client hasn't missed a mortgage payment by a single day since the party separated in April. We don't think that's something to be concerned about. We're more concerned about the fact that he's still covering essentially every single bill in Ms. Larson's household without the benefit of a court order, excluding food.
Okay. The Toyota Tacoma, is that is proposed to be paid by petitioner? Is that currently being paid by respondent?
Yes, Your Honor.
Okay. And then petitioner and respondent's cell phone bills. I don't know. I don't have a specific amount, but that would still be proposed to be paid by respondent per Ms. McLean.
Well,
I
it's
believe-
so yeah, telephone's $115 a month.
$115 a month for both lines.
Yes, Your Honor.
Okay. So then Ms. Margraft, the other expenses besides, you mentioned he's covering household expenses. So besides the first mortgage and the Toyota Tacoma, what else is he paying for as part of household expenses?
He's
Or-
paying the utilities in Kelso. I believe, and he's paying the car insurance for both the vehicles, of course. And obviously the health insurance. And of course, we have no objection to him continuing to cover the family during the pendency of this matter. I believe he was also recently contacted by Ms. Larson's father about a pump for the well. The expectation is that he's going to pay that. I mean, he's covering every expense that I can think of except, again, food.
Ms. McLean, what is your proposal, or do you have a proposal on the utilities and car insurance?
So I guess that if the court's inclined to have Mr. Larson continue to make these payments in lieu of spousal maintenance, I would simply want a caveat in there that he provide proof to my client of those payments. My understanding is that historically he's been delinquent in her Toyota Tacoma payment, which caused an increase in that monthly payment. So we certainly want to make sure that bills are being paid in a timely fashion so that they don't affect credit, particularly if there's going to be a potential refinance of the home down the future. Everybody needs to have good credit. My client also indicates that she has actually been paying her own vehicle insurance, that's not something that has been paid by Mr. Larson post-separation. So I'm not certain as to the claim about him making those payments. Based upon my client's financial declaration, the monthly utilities total about $363 per month. And again, I don't have verification that he's been paying those, but if he has, and if the court orders that he's to continue to provide those in the future, we'd want to make sure that there is some trigger for to provide proof to her on a monthly basis that he's made those payments.
I think that, go ahead.
Thank you. There was a single late payment involved, a late fee. There has been no rate rise in a monthly fee. Furthermore, I would note for the court that Mr. Larson has been making just slightly over minimum monthly payments on community credit cards to the tune of $600 a month, including one card, which he doesn't have any access to regarding the statements and has no idea what Ms. Larson is charging on there. And this is, of course, all post-separation. But speaking of good credit, he's very concerned about his and feels like he's backed into a corner to continue paying on these to ensure that his credit isn't negatively impacted.
Okay. So I think what strikes the appropriate balance here, and I take into account the length of the marriage, which is shy of 9 years, it looks like. And I take into account that if I were to order a spousal support of $2,000, but then shift the burden of the mortgage to the petitioner, as well as the vehicle, I think that in essence puts her in a worse spot. So what I'm going to do is strike spousal maintenance for those two reasons, but I am going to leave as currently being paid that the mortgage and the vehicle, as well as the other household expenses, I think the party said except car insurance, which petitioner is paying, the other bills will be paid by respondent as they're currently being paid. That in essence comes out to more than $2,000 per month.
And I'm sorry, did you indicate the utilities as well?
Correct. The utilities would remain in respondent's category for payment.
So would you just simply interlineate that at paragraph 9?
You know what? I can't. I kind of wrote on this order.
Oh, so do you want me to present a new one?
If you could, I used this as a little bit of scratch paper, assuming
Oh,
that
that's fine.
you would. So
Sure.
if you would be so kind, that
No
would
problem.
be helpful.
Sure.
Okay.
So essentially, Your Honor, we're staying status quo on all of the payments that my client is obligated to make.
Yes.
Okay. I'd just like to note, I mean, he's still underwater every month and we haven't even gotten to the subject of child support, which of course is mandatory, but he is struggling to cover everything. I mean, again, he just doesn't make enough to do that. Is there any way that we could ask the court to order the petitioner to cover the car payment?
So how is he covering this now? Are you saying that it's because he's not paying child support? That he's able to cover these bills?
I believe he's taking loans from family at this point because it's temporary phase.
Let me look at one other. With respondent maintaining the entire mortgage, the 1909, the cell phone bills, the utilities. I will, Ms. McLean, make an amendment to just the Toyota Tacoma going into petitioner's category for $254 a month.
Okay.
And I think that still puts her pretty close to that $2,000 initial request.
Okay.
I think that the other issue on this order, there is a request for respondent to pay petitioner's attorney fees. At that point, right now, that amount is $3,000. What I am going to do currently, and there is a gross discrepancy in pay here, I'm going to fully acknowledge that. I understand respondent may feel like he is underwater, but for the time being, taking into account the $1,800 in sanctions I awarded, I'm going to make the current attorney fee payment at $2,000 payment to Ms. McLean by August 30th.
Your Honor, under RCW 260914, he just doesn't have the ability to pay. We would ask at least that the request be reserved.
The request for the $2,000 or the request that he cover the attorney fees.
The attorney fees.
So what I'm going to do is just, what I'll say currently is that respondent must pay other parties' lawyer fees to date set at $2,000 to be paid at August 30, 2023. Future lawyer fee payments reserved.
I'm sorry. Okay, so just so I make sure, so I understand what I'm putting in the order. So you
Yes.
you are ordering 2,000 in addition to the 1,800,
Yes, I am.
and that's to be paid by August 30th.
Yes,
And and then you're reserving for future attorney's fees.
correct.
Okay. Okay.
Because we have reserved on, or excuse me, because we have appointed a GAL for the temporary parenting plan, I'm going to reserve on any of the 3A or B limitations. I think we'll address that once we have GAL involvement. So for now, we'll reserve.
Okay.
Decision-making, the proposal I have in front of me from Ms. McLean does put that with Ms. Larson. My understanding right now is that Ms. Larson is that primary parent. Ms. Margraf, is your client requesting something different for the temporary order?
Absolutely, Your Honor. We're requesting joint decision-making. We're not disputing the fact that Ms. Larson has been the primary parent because my client has been the primary wage earner. We would also like to note that there are no less than 9 separate areas in which she's requesting sole decision-making, which we would like to offer as evidence that she's got a massive control issue. And we're asking, again, that joint decision-making be ordered, and absent that, at least reserved for the report from the GAL.
What is respondent's current role with regard to parenting time with the child?
Whatever petitioner will permit. And there's been extensive back and forth about that. But I would point out that during the various times when petitioner was seriously ill during chemotherapy treatments, it was my client who was handling the day-to-day. And even when he was driving into Vancouver from Kelso 5 days a week with a 10-hour absence from the house when he got home, he did everything he could to support petitioner in housekeeping, was doing as much cooking as he could, spent time with the child, read to her, tucked her in, bathing, the whole bit. Since this separation, there's been ongoing disputes, in fact, including information submitted by petitioner herself showing, in my opinion, intransigence when it comes to allowing time with respondent's own child. But when he does have a chance to parent, he's a very involved parent.
Ms. McLean.
Well, first off, I would point out that some of that is outside of the scope of the declarations that have been submitted to the court. And my client needs to have an opportunity to respond to that type of information and those allegations. My client tells you that even when she was at her sickest, that she was still the one that was parenting the child and providing for her. And I think, contrary to counsel's suggestion, when you take a look at the attachments to my client's declaration that was filed in response to the substantive motion that we filed on June 29, you see the text where originally Mr. Larson claimed that my client withheld his ability to attend or participate in Rue's Taekwondo class. The first couple of pages of those attachments show where, in fact, he was invited to participate, but it was work that got in the way and why he wasn't able to attend. In addition, my client is consistently saying, look, we need to communicate through text or emails. Basically, she wants a thread that she can provide to the court, and he absolutely refuses. He says, nope, we have to talk by phone. I'm not going to do this. Look at the I think it's the 4th page of text message communication. Let's see, it's the 3rd set from May 27th, where he says, and this is the Saturday of Memorial Day weekend. He says, as you know, I'm coming down tomorrow to see Rue. Does she have anything planned tomorrow that will prevent me from seeing her like last weekend? So basically, he's giving her less than 24 hours notice that he's planning on coming down on a holiday weekend. He never communicated that ahead of time. My client says in the dark right-hand justified, I actually didn't know you're coming down tomorrow. I had no notice of you coming. Yes, we're busy all Sunday. He says, you were there when I said last Sunday that I wanted to take Rue to the movies on Sunday, Memorial Day weekend, that I would be coming down on Sunday to Monday. She says, I have no recollection of that conversation and don't know what you're talking about. And it just goes on and on. He goes on to say at the bottom of that next page, I do not have to request visits with Athena. I can come down there and visit my daughter anytime I would like, because I'm her parent and I can come down there and have fun with her. I do not have to make requests. What I'm doing is making sure that she doesn't have a scheduled weekend, because you like to plan a lot of things and aren't being very communicative to what you guys are doing. What needs to happen is that we actually talk over the phone and go over weekend plans so that we don't double book with Ryan.
Okay.
This is the type of case where you would instill the Our Family Wizard or the Close app for parents so that we have a clear indication of communications, and he's resisting at every opportunity. So my client's trying to be reasonable. He's being overbearing. He's trying to throw his weight around. Up to that point, I don't believe he had an overnight visitation, even though they had separated 2 months previously. And since then, he's been extremely demanding. So my client has requested, and quite frankly, when you go back and look at his declaration, he lives 3 hours away. He's basically demanding that this child be in a car for 12 to 14 hours a weekend for his visitation. In the past, he had the ability, and I believe still has the ability, to stay in mother-in-law quarters at my client's parents' home and spend that time with Rue so that they can have visitation where this child isn't sitting in a car for all those hours. So we proposed a specific schedule, but he has to be off work. That's a concern of my clients, because given his position, he gets called, and you see him from the text messages. He's called into work all the time. That interferes with his ability to parent, and Rue shouldn't be in a vehicle, not only for that length of time for transportation, but also during her visitation so he can do work. So we're asking that the court adopt our proposed parenting plan, which is the 1st and 3rd weekends as defined by Fridays. From Saturday to Sunday, he can exercise down at the mother-in-law's quarters at my client's parents' home. And that we believe would be appropriate for Rue.
So just going a little bit backwards here, but I think what I am going to do right now, and I will re-review after GAL involvement, I'm going to keep Ms. Larson as primary on extracurricular, driver's permits, haircuts, piercings, all of those things. That's going to include religious decisions. I am finding her to be—
Your Honor, I have to object. I'm sorry. That's a violation of his inviolate rights.
Just hold on a second. Can you let me finish?
Sure.
Okay. So they're going to be joint decision-making for now that will be re-reviewed on school, educational, and healthcare, not emergency. Ms. Margraff, you're objecting to her being primary on religious decisions on constitutional grounds?
Yes, Your Honor.
Okay. My ruling stands because she is going to be the custodial parent. I'm going to find that he lives too far away to right now be involved in those timely decisions where I have listed her as the primary. I am going to also adopt Ms. McLean's proposal that he be evaluated for anger management. I think the evaluation should consider input from the other parent and the guardian ad litem. I think I already said on number 7, the custodian will be Ms. Larson. Dispute resolution under number 6 will be the court. Let's talk about the schedule as proposed by Ms. McLean. This is the 1st and 3rd weekends. Ms. Margraff, what is your input on that proposed schedule?
I think it's completely inappropriate and far too restrictive for a variety of reasons. It's true Mr. Larson lives several hours away. The mother-in-law quarters are not available to him, and considering the interactions he's had with the people in Ms. Larson's family recently, he doesn't feel at all comfortable on that property. Furthermore, I would note from the texts that were submitted That interaction in May involved obviously some sarcastic commentary from Mr. Larson because again and again, he had been denied access to Rue. At that time, there was no parenting plan in place. Technically, he didn't need permission to see the child. There was several different incidences involving the Taekwondo. I believe what's being referenced to in the reply declaration was a separate incident. There was another time where he was told he couldn't come see the child because of the Taekwondo. Whether he stays in Kelso anywhere with Rue or goes elsewhere, Saturday to Sunday is far too restrictive. It's less than local rule and it's totally inappropriate. And besides, as noted before, he doesn't want to make use of whatever offer may be pending to use that mother-in-law property. I don't think any reasonable person would feel comfortable in such proximity with the Ogrins. So we are asking that the court adopt our proposed schedule. We are trying to factor in as much time as possible and as little travel time proportionally every time he has parenting time with Rue. We vigorously disagree with the assertion that he should have first and third weekends from Saturday to Sunday.
What
It's
is he
not
doing?
the time.
What is he doing currently?
Whatever Ms. Larson permits. He had Rue overnight, I think at the earlier part of June, then for Father's Day, then based on prior agreement between the parties, he had her again the weekend of the 30th. Pardon me, my calendar is not open. Yes, the 30th. And had her from Friday to Monday noon.
And this is, so your proposal is every other weekend from Friday after school to Monday morning school drop off?
Yes.
And that would obviously be during school times. So how is he going to make that work, dropping her off at school Monday morning, given his location?
Either a very early start, or I understand the parties have discussed the possibility of homeschooling.
Okay, without the possibility of homeschooling, how is he realistically going to guarantee that every other Monday morning he's able to do drop off at school down here?
He's not, so if the court feels it's necessary to order Friday after school to Sunday evening, we would absolutely understand and be satisfied with that. But so long as summer is occurring, we think a Monday morning drop off is appropriate. He's made arrangements with work to have a hybrid schedule on that day to accommodate travel time.
I think that makes sense, especially right now where I don't find any reason to limit his visitation. I am going to adopt the proposal
I'm
of.
sorry, may I just be heard on one thing?
Sure. We got it. We do need to wrap this up.
I understand. The Friday after schools, he can't currently even meet at 6 p.m. He was supposed to meet at 6 p.m. This most recent weekend that he did, and he was late because of traffic. I don't know how he's going to be able to make a 3:30 school time when he can't make a 6 p.m. time. So, and my other concern is alternating weekends are very difficult to enforce because you have to go back to a calendar, go his, her, his, her, his, her. So we would ask that you define that as first, third, second, and fourth, first, third, fifth, second, fourth, fifth, something like that.
Your Honor, that was a single occurrence. If he didn't make it there because of traffic, if he has a court order stating he's picking up his child at 3:30, he will be there at 3:30 every single day he has court appointed times to pick up.
Yeah, that is what I'm going to propose. If the parties want to put in a specific schedule that is first, third, fifth, when there is a fifth, I am fine with that. To me, it's clearer just to say every other weekend because you do have some months where you have more weekends than others. But if the parties both agree that they want to put in a number on that, that's fine. But essentially my ruling is every other weekend, Friday to, we are going to change that to Sunday night. Let's say 7 p.m. Gets kiddo home before bedtime. That will be the visitation schedule. The summer schedule will be the same as the school schedule, but I will adopt the recommendation that each parent will get to spend 2 weeks of vacation time with the child during the summer. That will include 2 weeks with the respondent.
Are those 2 consecutive weeks or 2 singular weeks?
So the proposal from respondent is consecutive or non-consecutive. So I don't know, Ms. Margraft, if you have any edit on that or if that's still your proposal.
That's our proposal. We'd like to offer flexibility for all parties involved.
Okay. Ms. McLean, you're.
The client's not been more than a couple days, if at all, away from my client. So given her age and the newness of the separation of these folks, I think it's appropriate that we limit it to no more than a week at a time.
I think that's appropriate. So we'll say 2 weeks of vacation each summer, 1 week at a time at most with respondent. Okay. And I assume no objection to the father being responsible for the visitation transportation.
No, Your Honor, but if it's at all possible for the parties to coordinate, if petitioner is going to be in Tacoma, that would be ideal. I know that occurs every so often, and that would be a boon to him. Although I understand those appointments are usually on Mondays so far.
Okay. And certainly I won't stand in the way if petitioner is available during a visitation weekend and can help arrange transportation. That is obviously fine, but I think given the facts of this case and the petitioner's particular issues, the father will be responsible for that visitation
I
transportation.
have a few other questions about the orders before we wrap it up though, as well.
Absolutely. So we'll do presentation August 1.
Okay.
And then Ms. McLean, you had asked one other question. I didn't write it down.
Whether or not Mr. Larson has to be off work during his visitation.
Okay. So Ms. Margraft, does he work a Monday through Friday schedule, or does he also work weekends?
Generally, he has weekends off. But we would also note that whether or not he's working during his parenting time is irrelevant to whether he can have visitation.
Yeah, and I understand that, and that is not quite where I'm going with this. I guess the question is, does he have childcare where he currently lives if he is working during a visitation week?
He would be able to arrange it. Absolutely. Yes.
So I'm going to decline to put in a requirement that he remain off of work at this time. Should an issue come up through GAL investigation that whatever childcare he is arranging during his visitation times is not appropriate in some form. I don't have any information to suggest that at this time. So Ms. Margraff, then I think you had some questions or clarifications.
I did. We strongly object to the clause in the proposed parenting plan that indicates that my client needs to have a background check run on any potential romantic partners. We'd like that entire clause struck.
So what I will do is strike that from the parenting plan, but I will note that obviously per GAL investigation, if there were a significant other involved, that could become a part of this case, but we can reserve addressing that issue for further in the case.
Okay, we've never had any indication that he's got any issues. Well, he hasn't had a romantic partner in over 10 years, but regardless, let's see, we'd also like to request the start date for the child support be in July. We feel that would be a retroactive award for a June start.
Well, this matter was filed.
Yeah, this case was filed in April, and I think I have found some good cause to set aside his failure to timely appear in this case. So I'm not considering June 1st to be retroactive, and I will include the June 1st date.
Is the court entering the provisions that we had proposed in the parenting plan under 4A2 as far as not talking negatively or allowing third parties to talk negatively?
Yes, I wish that was just kind of general template language for these cases, but yes, I do want the language that the father should be enjoined or restrained for, well, I would say both. Let's change that to all parties are enjoined and restrained from talking negatively or allowing third parties to talk negatively about the other party to the child.
Okay.
Yes, that's actually my template language for section 14. It's in there always.
Okay.
And
So
then
go ahead.
paragraph B about having him provide my client notices to where the child's going to be.
Yes, I do think, given how far away the child will be from Ms. Larson, I do think that the father should provide any contact information for where the child will be located during visitation. I think that's appropriate.
The request about no unsupervised contact with the paternal grandparents.
Your Honor, we object to that. That's absolutely overreach and there's no reason for that.
Yeah, I did put a question mark by that, and thank you for bringing it up. We didn't address that. And perhaps I'm missing it in some of the documents that are filed, but what is the basis for that request?
The significant alcohol consumption by the grandparents that was noted by not only my client, but her two witnesses, and the history of the grandparents to drive with road beers. They feel it's acceptable to drive both intoxicated as well with open containers.
Your Honor, that's absolutely untrue. And I'd further note the allegations that petitioner made regarding that preceded her request that Ms. Larson be an unsupervised caregiver for a spontaneous trip to Egypt, where she had the care of Rue for 2 weeks straight. There was no issue with any allegations about inappropriate consumption then. And I would also notice that Connie Ogden has never been to a holiday meal with her. So
yeah, I'm going to decline to include 4.2C. I don't think there's enough information for me to do that at this time. Certainly, again, if the GAL's investigation regarding contacts with paternal grandparents becomes an issue, we will certainly readdress it. I think I'll also strike 4A2D. Well, I mean, this really applies to both parties. I would prefer that neither party have consumed alcohol or illegal drugs 12 hours prior to their residential time with the child. I think that that's fairly standard.
sure, we have no objection to that whatsoever.
And then
parenting classes for the father.
Your Honor, there's no call for that.
I'm going to reserve based on GAL review. I am ordering the anger management based on what I've reviewed in the declaration. So I'm adopting 4B1 to occur even before the GAL report, but I'll reserve on the parenting classes.
Okay. All right. I don't have any other questions. Thank you.
Yeah, thank you. Somehow I skipped over those pages, even though I did put question marks by them. So thank you for bringing that up. Ms. Margraff, any other points of clarification?
Yes, which holiday schedule are we adopting?
Well,
For example, the Thanksgiving Day schedule is impossible for my client. Thanksgiving Day period from 12 noon to 6 p.m. I think the one that we suggested in our proposed parenting plan is a lot more flexible and easy to follow, especially considering the fact that his parents live in Yakima. So if he wants to see his parents with his child, he's going to have to go over White Pass to get there in late November.
Well, this year would be allocated to my client, so that's certainly something that the guardian ad litem can weigh in if they think it's appropriate to be changed.
I disagree. I think the
And it
commission
would-
should make a
and it would
rule on
still-
that.
And it would still keep his weekends intact, assuming that that was his weekend of Thanksgiving.
I just think that this holiday schedule is too restrictive. Again, Christmas Eve and day, December 23rd to December 24th from 6 to 8. Those are too short. Those times are too short. And same goes for Father's Day. I mean, that should just be the whole weekend.
Well, perhaps we just reserve them for GAL input, since we're going to have a GAL report back by November. We're in hearing on November 14th. So that would be before the Thanksgiving holiday and the Christmas.
I think, yeah, since there isn't a major holiday before we meet next for review, let's go ahead and reserve on the holiday schedule. I just will tell the parties, I do think that those times are a bit restrictive as proposed by petitioner. So while I don't have a ton of heartburn about how it's broken up, I would tip it, especially for Thanksgiving Day and Christmas Eve, probably would extend those times to allow more time with the parent who has visitation. But that said, let's go ahead and reserve and get some feedback after GAL meets with the parties involved.
Honor.
And I assume you're not objecting to either of those.
No, absolutely not. I just think it's sort of countermanded by the decision for sole decision making about religious upbringing.
Yeah, no, it is. So Ms. McLean, what's your proposal? Because I think you both had proposed that she be primary on religious upbringing, but subsection E allows each parent to have equal rights to include their child in their religious activities.
I would agree to go ahead and strike that.
I think it should stay in, Your Honor. It was in mine as well. I think every parent has the right to include a child in religious activities. And I'd also note that since Father's going to have every other weekend, or first, third, and fifth, second and fourth, whatever the case may be, that would encompass Sunday. Does this mean that my client wouldn't be able to take his child to church if
Yeah.
Ms.
So-
Larson objects? I don't think that's fair.
So let's keep in petitioners proposed E and F. I also agree with the media, telephone and telephone access, but that will amend my decision to include under 5A that religious decisions will be joint. Okay, and if there's something that, again, that comes up as you all are going through preparing this order, we can address it at presentation.